future behind me. Na 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 na. I'll keep going, nothing can stop me. Na 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 na.
Well, hello everyone, and welcome to an extra episode. Yeah, I know, Manuel, not expecting a live stream today. That was unintentionally the plan. I like when it's just me, I like doing it from OBS. If you guys can share it, because I'm currently having to, like, how Restream works is that if I'm going live via OBS, I can't exactly very conveniently schedule it. And then I also have to now hand type in for all the platforms the description to share it on the platforms that I'm on. It's a pain in the ass. But I prefer using OBS when it's just me because it's just easier to like live stream. I can go between slides however I want to. I can design the setup however I want to, and I don't have to play by Restream's stupid rules. Mic seems low. Let me try and fix that. First let me see what the mic is showing. Properties. It is showing the Yeti mic. I bet I know what the problem is, because it does this every fucking time. Yeah, it's... See... What? One second. Okay, so these are all set. Properties, levels. Okay, it's all the. These are all the default devices. Is that helping? Is that better? I don't know what it is, but Microsoft likes to, in software, mess with my volume levels on my microphone. And I don't like that. I hate when it does it. It does it every time I am running this. Let me turn down the gain on this a little, because it looks like I'm hitting the... Is that better on the audio? Okay, that's good. So where was I? Yeah, so I was wanting to catch up on some of these lawsuits that I haven't been able to get to. Plus, we have wonderful people to, you know, have a few drinks and talk about, because they had to have a Spaces call about the whole shenanigans going on with FINRA responding to them and their whole conspiracy shtick with that. So I have a fun night planned. I have a fun night planned indeed. I'm pretty sure right now, yeah, you're the only one watching, because I kind of like spur of the moment did this. Let me see if I can get some tags, and then maybe that will help us here, because right now I don't have any tags. Now I understand why people do the long intro song so they can get everything set up when they're using Restream. Because I now understand completely. Maybe I should get a longer intro thing so I can work on this beforehand. But anyway, I've got several lawsuits here, so I can talk about some of them while we're... Oh, you've been drinking too? Well, it's going to be a great night together. I can already tell. Suits. There we go. That's the one I was looking for. Okay, so now I can maybe pull this over and do this on the Rumble side and get that fixed too. Edit, choose file. because we've got some lawsuits to go over that I don't normally get to. So the first one was with Scott Troud. Can you lower your mic 10%? I can definitely do that. In fact, I don't think I'll do it from the hardware side. I'll do it from like, how's this? Is that a little bit better? What I need to do is I just need to reinstall that thing that Scott told me about and just, you know, be able to adjust my levels a lot better. Again, I'm not a professional. I don't get paid to talk about the stock. You know? But Scott Troud had his lawsuit that he's got, Troud v. Gensler, that recently took an interesting turn. I'm kind of surprised. Usually when you have these meme stock lawsuits, what happens is you've got these people that like to basically bang their head against a wall, or they'll just keep fighting until the point of no return. Scott actually, you know, as much as I don't agree with everything, all of his legal conclusions, he actually was smart about this one. Now let me pull it up here. He actually responded to the SEC's motion to dismiss with something that was actually halfway intelligent. Oh, yay, we got someone over on the Twitch side now, too. And that was actually halfway intelligent. Instead of banging his head against the wall and expecting different results, he actually decided, since the court in a previous motion decided that, you know, he had the wrong court, that the circuit courts do not have, I sympathize with shareholders that got bagged, but the lawsuits are trash. Yeah, 100%. They're usually all trash. He realized that for a writ of mandamus, you have to go to the Court of Appeals, the appellate court, which I believe is the Second Circuit. It's in here somewhere. We'll get to it. But he realized, okay, well, if the court is telling me this is where I need to be, then maybe I should do it. So he submits a response to defense motion to dismiss and makes a motion to transfer the action to the, Second Circuit Court of Appeals, which, yeah, that would be the thing to do. And he's saying that, you know, in the interest of justice, it should be transferred. Kind of agree with him there. He should have started in the Second Circuit. The judge in this case has been kind of lenient. I mean, most judges are. Now, if it's a matter of, you know, you should have filed this here and there, they're not exactly. They're going to treat you like a normal lawyer would, unless you ask for an extension. But for the most part, he's a pro se litigant. They're going to give him some leniency when dealing with these sorts of things. Come on, let me. But he also got a stay, which, again, and the court already approved this. That's on the docket. So he's asking for a 7-day stay of the proceedings to try and figure out what his options are. If he wants to kick this up to the Second Circuit where it belongs, since this is a request for writ of mandamus, or if he needs to let this case die and then refile in the Second Circuit, or I think he will get his motion to transfer. Like, again, not a lawyer, but I do think that, like, it seems reasonable that he would get his motion to transfer, because, like, everyone's already agreed on this case that it should have been in the Second Circuit to begin with. So I wouldn't be surprised if after this 7-day stay they just transfer it to the Second Circuit. But then again, since it's an appellate court and this is like a circuit court, can they just transfer it up there to the Second, or does he have to kill this and then start over again? Because that would be really annoying if he just had to start this all over again. But I mean, that could be what happens because it's an appellate level court. It'd be interesting to see what happens because it's something I've never seen before. Like, again, I'm not a lawyer. I don't have this kind of legal experience, but I wouldn't be surprised either way if they let him transfer because, I mean, he's pro se. Like, he's going to make mistakes. Just let him transfer. Or it could be just a strict rules thing of we can't transfer to the Second Circuit, so you're going to have to kill this case and then start all over again. Sorry. Speaking of starting all over, this one was really funny. I know this was last week, but we didn't get to it really. Apparently, the MMTLP crowd was really surprised that you can appeal decisions. So everyone was shocked and aghast when in the Taggart v. Nextbridge Hydrocarbons et al. Case, they decided to appeal to the Fifth Circuit. I still don't think they'll win. Like, I get the arguments that the district court made. I get them. I understand them. I don't agree with them, and I think the court, understood that we're not saying what they did was great, but under current precedent, there's nothing you can do. Manuel, I also cringe every time I see a litigant admits that they don't know anything about the stock. Well, we'll be getting to that. We'll be getting to that when we start listening into the things from today that were really silly. Because there was some stuff that was really silly from today of like, well, I don't know, or not legal advice, or I'm not a lawyer, or I don't understand this. It's like, well, if you don't understand it, like, I get one thing, you're saying you're not a lawyer, don't take my advice at face value. But if you're playing this I don't know game, but I'm going to guess this thing about my conspiracy theory is true, just shut up. Like, if you're admitting you have no understanding of the subject matter, why are you talking? Oh, let's see here. Got that. Probably messed that up. There we go. What's the next thing on our list? Oh yeah. We have like for the first part of this, it's going to be MMTLP stuff. We're going to have a lot of MMTLP stuff to go through. This one, I can't believe we missed this last week, that we didn't have time for it because it's so funny and it's so freaking stupid. Okay. I haven't read these yet. Oh yeah, here it is. So they had their memorandum of law in opposition to motion. Who is that? Oh, okay. So this was Jason Rollo's. No, that's the Security and Exchange. Okay. So there's, so on July 9th, we got the response to FINRA's supplemental authorities by Jason Todd Rollo. Then FINRA responded on August 5th. Let's see here. If I remember, this is going to be hilarious. Pursuant to rules of Civil Procedure 11 and Connecticut Rules of Professional Conduct, defendant in financial and regulatory industry hereby submits this notice to inform the court of multiple false citations. Yikes! False citations. Every single quotation of purported legal authority in Rollo's response is false and appears to be an artificial intelligence hallucination. The most problematic is Rollo accusing FINRA of providing a misleading and incomplete account of the Trout-Rubenstein case decision and representing the court. The Trout court especially stated the court cannot say that all claims against the SEC fail as a matter of law, especially those relating to the agency's oversight responsibilities. This recitation of Trout's ruling is patently false. Nowhere in the Trout opinion does the court state anything close to what Rollo represents. Off to a great start, aren't we? Oh, it's only 4 pages, but like, I will say this as someone who, I may not be a lawyer, but I am legal adjacent. There's a lot of states, including the state I'm in, Kansas, who now at the end of filings, you now have to put a certified disclaimer in there that says, this filing was not created using artificial intelligence per local rules. Like, there are now local rules for local district courts in states where you as a lawyer, because of stuff like this, I mean, not even pro se, there's some lawyers who have had their license to practice law taken away because they used AI to generate fake they didn't know. Well, they should have, because they should have been checking the AI. But fake citations that do not exist, and they did not fact check the AI before submitting them to the court. Like, okay? So, this is what we're talking about here. If Rollo in this case was a lawyer, he would be disbarred. So I get that he's pro se, but think about those level of sanctions when they're discussing this. If he was a lawyer, his ability to practice law, his job, his livelihood would potentially be on the table and taken away. That is the level of affront to the legal system that he has done. I would love to be an AI-induced hallucination right now. Well, I can't help you with that, and I wouldn't want to do that. We've covered some of the articles about people's AI hallucinations, and now we have almost AI cults. Not looking forward to that future. If you thought Idiocracy was bad, Idiocracy by AI sounds like worse somehow. I don't know. Let me see here. Rollo's response likewise contains the following additional non-existent quotations. Trout v. Rubenstein. Plaintiff may file a motion to amend or correct the complaint and attach a proposed amended complaint that complies with the local rules of the district court. Plaintiff did not file a proposed amended complaint, did not correct the verification defective, and had failed to submit evidence. And then supposed citation from DL Cap Group LLC versus NASD. And SRO is not entitled to absolute oh, we already know that's wrong. Absolute immunity for all of its conduct simply by virtue of its status. Actually, it is. So long as it's doing stuff that's within the legal framework of its SRO, its government, its regulation function, it is absolutely immune. That is current case law. Sparta Surgical versus NASD. Actions taken outside of the scope of a regulatory function may be actionable, but I mean, like, I've yet to see any of these MMTLP people show an actual instance where they've acted outside of their regulatory functions. Like, riddle me this, Cape Crusader. Where is that? I'm not seeing it. I'm not seeing where, like, they've ever acted outside of their legal authority. So I don't know. Just a thought. Just a thought. The improper and it is improper and unacceptable for litigants, including pro se litigants, to submit non-existent judicial opinions with fake quotations and citations. Anonymous versus New York City. An anonymous lawsuit. Amazing. Plaintiff's brief built on AI-generated cases that stand for legal propositions in direct contravention of actual case law is the epitome of baseless. FINRA is compelled to highlight the foregoing false legal quotations to the court consistent with its duty of candor pursuant to Federal Rules of Civil Procedure 11B. Furthermore, it's the duty of candor to the tribunal applies to pro se litigants as well as attorneys. Yep. Wherefore, FINRA respectfully requests that the court strike Rollo's response and issue an appropriate warning to Rollo regarding future filings. Yeah. Whether the issue with plaintiff's filings are the result of artificial intelligence or some other mistake, the court cautions plaintiff to ensure that future submissions contain only accurate representations. Yikes. Well, at least FINRA is being nice, because they could have asked for a lot worse there. Just saying. This could have been a lot more of a problem for him, but he got lucky there. Alrighty, so me. Get that out. Alrighty, so there's that out of the way. Then we get to Kelly. Oh my goodness, Kelly is also silly. Look, we talked about, I think, not this live stream, but the one before it, about how he was trying to shoehorn in discovery by doing a motion for preliminary injunction, and FINRA goes through 24 pages about how this is absolute bullshit. I'm not going to read them all. It was pretty obviously dumb when I went over it, like when it first came out. Like I made a tweet on X or Chitter, Twitter, whatever you want to call it, basically pointing out how absolutely freaking dumb it was. Like, these people understand that they're never going to get to discovery because their claims are verifiably frivolous. So they always look for these ways that they can shoehorn or go around or do an end around the discovery process and get discovery before they're rightfully entitled to it. And they've been playing these games since the start. This just happens to be the newest thing. Hijack the injunction process, injunctive relief process to try and get discovery. And he responds, oh my God, it's 65 pages. How many of it's actual argument? Because I'm not going to sit here and read 65 pages. 26. Okay, first of all, I'll point this out. I don't think it needs to be pointed out too hard, but you were not likely to succeed on the merits. Like, what is this? The MMTLP versus FINRA crew is like what, 0 for 12 at this point, trying to get some sort of case against FINRA because, again, as has been pointed out time and time again, they are absolutely immune. Absolutely immune. The only people that regulate them is the executive branch, the SEC. That is the cop on the beat. Go, if you have a problem, go get the SEC. What was it about you guys? You said Trump was going to get into office and suddenly everything was going to be better for you guys. And then they've got the new SEC chair was just appointed by him. Why don't you go knock on those doors? Like, these are the people that are responsible for FINRA, that gave them their SRO charter, the ability to be an SRO. If you have actual evidence, not made up fictional evidence, I mean actual proof, then like just go to the SEC. That's their job. That's what they do. They watch the Watchmen. FINRA claims immunity under Sparta's article. The court has made clear that self-regulatory organizations lose immunity when acting beyond their delegated authorities. Yeah, but they haven't been. FINRA unilaterally revised, no, they didn't. It did not unilaterally revise the MMTLP corporate action. It did not. Did not. What? Like, where did this, like, fairy tale come from? I want to know. Because that never happened. Like, Manuel, you're going to have to help me out here because I have no clue what they're talking about when they say that. FINRA's reliance on regulatory immunity assumes deference with their interpretation of authority. Well, guess what? You don't get to interpret their authority. Just so we're clear. Overturning Chevron deference was, oh my god. Requires courts to independently determine if an SRO's within its statutory bounds. Like, first of all, like that whole Chevron ruling is not relevant here. Jesus. FINRA's unilateral revision of corporate action. It didn't do that, though. It didn't do that. Furthermore, FINRA failed to consider less harmful alternatives, such as it gets to do that. It gets to do that. And first of all, like, you're trying to use this to get discovery. That's not how injunctive relief works. You have to enjoin them from doing something. What is the thing you're enjoining them from doing? Like, let's see if they get to that, because we already know they're going to lose on the merits. Plaintiff has suffered and continues to suffer irreparable harm. No, you have your shares of NextBridge hydrocarbons. There is no irreparable harm that you were suffered. You got exactly what you were told you were going to get in the S1. Your shares of MMTLP would be converted 1-for-1 into NextBridge shares. There was no irreparable harm. So strike two. I'll skip over that dumb argument. Balance the equities and public interest favor the plaintiff. Okay, so they're going to take point 3 and 4 and mess. We're going to get to that motion to quash. Don't you worry. That, like, this is why I'm playing catch up with all the MMTLP stuff. We will get to that silly motion to quash, because it is comical beyond belief that the comments they had for it. I had that space call. I chopped out most of the busy work in it, but not all of it before this live stream. We'll see how much I can chop it up to make it fit on the Saturday show, because I don't want everyone missing this. But man, it is an assault of stupidity. That's why I got the alcohol going, because by the time I get there, I'm gonna need all of it. Like, the little bits I heard just made me like feel like I was being physically assaulted with stupidity. FINU argues that the burden of disclosure inflicts a great hardship and routes anyone and suffers no hardship, but the request is narrow. No, it isn't. You want the entire fucking blue sheets. That's not narrow. Additionally, plaintiff has gathered numerous investor stake. Who cares?
You are the only plaintiff here. This isn't a class action. You are the sole person that is plaintiff here. Who cares about what statements you garnered from everyone else? No one gives a fuck. This is your lawsuit. This is not you and your friends. If you wanted a class action, you would have hired a real lawyer. Not done this fucking soft-sit bullshit. Defendant's reliance on local rule 26.6c is misplaced. Plaintiff's request for limited target discovery arises not. You don't get to ask for you don't get to ask for discovery yet until you get past the motion to dismiss phase. That's under the SLURA. That's how that works. You don't get discovery until you pass the motion to dismiss phase. And you don't get to use injunctive relief to try and jerry-rig your way to discovery. It's not how injunctive relief works. Courts routinely permit limited discovery, support PI proceedings. Yeah, no, but the SLURA rejects that. Like, if it was any other lawsuit, sure, you could maybe start the discovery process before you get to the motion to dismiss phase, but no, it's not how it works here. Plaintiff's reliance on DeBurr's Mines versus United States supports the request for preliminary injunction to preserve the status quo. Yes, that's how injunctive relief works, to preserve status quo. What status quo are you trying to preserve here? The Supreme Court recognizes that courts may issue preliminary injunctions to prevent actions. Yeah, what action are you trying to prevent that would render a final judgment ineffectual? Although the court reversed the injunction in De Beers because it exceeded the scope of the ultimate relief sought, the principle has been okay. Yeah, like, can we get to the point here? Moreover, the plaintiff made good faith that's like, no. What are you trying to enjoin? What is your what are you trying to stop? What are you trying to enjoin? That's the problem with this entire argument. I deserve injunctive relief because I will win on the merits and the balance of equities favors me. Assuming all that. We'll let him assume all that. Like, he never gets around to what he's trying to enjoin. What are you trying to enjoin? Oh, well, I want discovery. That's not enjoining anything. Like, it's like legal scholarship for retards. Like, what even? This makes no sense. It makes no sense at all. What are you asking for? And he won't ever answer what he's asking for, because if he ever answered that question, his entire legal argument falls apart. Because he's not asking for injunctive relief, he's asking for discovery, which he doesn't get at this stage of the lawsuit. Local Rule IC 2-2 does not apply to plaintiff's pro se filing and cannot be a basis for denial. Local Rule is, again, misplaced. Local Rule governs procedures specifically for electronic filers, requiring them to select the appropriate event times for each type. Yes, it does apply to you, because you're trying to get early discovery, and you filed it as injunctive relief. You don't know that's their point. You don't get to try and play this end around game. The court has personal jurisdiction over FINRA. What court is this in? Nevada. No, they don't. I can tell you that right now. They do not have jurisdiction over FINRA. That's been well established. The district that has jurisdiction, like, there are several ways in which a court can have jurisdiction over you and determine proper venue. For companies, it's either the place they're incorporated or the place where their headquarters are, the nerve system of the company as it is. So in this case, it would be either Delaware or the DC Circuit Court for FINRA. And unless, like, you have some long-arm statute, or you find a way to prove that FINRA does things in the state that's so continuous that they would be at home in that state, but all of their interactions are regulating things that happen in, like, the stock market, stock exchange on OTC. At best, you could maybe make an argument that if you went to the Southern District of New York, you could long-arm them in there, or try and say that, you know, they regulate things that happen on the stock market exchanges, so New York, the Southern District of New York has jurisdiction. Like, that's the best argument you could come up with. The idea that Nevada, of all places, has like some sort of jurisdictional nexus over FINRA is so comical. I don't even know. That's just silly. The court has personal jurisdiction over FINRA. Nope. FINRA's legal immunity is not absolute. No, it's kind of in the term. It's absolute immunity. If they're doing something that's within their regulatory sphere, they are absolutely immune. That's the name of the game. FINRA continues to cite Sparta and other cases it can, regardless of the motivation, ignores the Ninth Circuit's own clear holding that SRO immunity does not apply to actions taken. You have yet to establish a single time that it has taken any action outside of its regulatory authority. Not once. None of the people in MMTLP have ever established that. Private right of action exists for constitutional evaluation. But again, yes, there is a private right to constitutional actions, but the problem is as has been pointed out by FINRA, there's no particularized constitutional violation that has happened. Like, what are we doing here? Like, this is silliness. This is constitutional silliness. Like, to have a right of action, you need a particularized loss, a particularized injury. And also, by the way, the fact that those 2 days, because of the T+2 that were taken away, that also does not constitute a government taking, is the silliest argument that has ever sprung forth from Scott Trout's mouth. No. First of all, you got your Nextbridge shares, so there was no taking. You got exactly what the corporate action said you were going to get. There was no government taking. Right? Ugh. Like, I don't even. And second of all, you have to have a particularized injury. What particularized injury that is pursuant to, like, again, they're not, like, they've been given government power to regulate, but they are not a government agency. That's how SROs roll. FINRA qualifies as a state actor. Nope. This is, yeah, no. Also, apparently, he did a whole FOIA request. What was the FOIA request about? It doesn't say on here. Text from disclosure records compiled for law enforcement purposes. Oh, I guess he was asking for the blue sheets. Is that what this is about? Because if so, that's kind of silly. Conducts its investigations on a non-public basis, therefore subject to the provisions of the FOIA. Yep. Like, this is what they've been told every single time. Like, I don't get it. Like, they've been told this so many times. How can you not get it at this point? Like, how many times does this need to be spelled out? It's not like they haven't been told this before. They've been told this several times, multiple times, and they still don't get it. How many times do you need to be told how all this works? I have a sad feeling we're going to be here till the end of time, waiting for these people to learn how the law operates. Let me get this because I want. I want this to come in here. Actually, what I want is sign in. Sorry, I'm having a pulse on nub. Yep. Use that. Continue. go to my account on Adobe. Sorry, standing by because we're getting ready to go into the new topic of the day. Okay, cool. Stop that. Adobe Acrobat. Cool. All right, so let's drop this in here. Come on. Because I want to be able to highlight stuff. Cool. There we go. So after all of that silliness, we get to the topic du jour of the day. Oh boy, this is a work of art. Sorry, I got some message from people. Yeah. So, non-party financial industry regulatory authorities motion to quash the subpoenas. If you've not been paying attention, there was the motion to dismiss in the. Oh, I'm sorry. There's the bankruptcy, the metamaterials bankruptcy, and they sent out a bunch of Rule 2004 discovery. Rule 2004 discovery is for things to determine assets and stuff like that of the debtor. It's a tool not only for the debtor, but for the creditors and other people who are parties in interest in the debtor to be able to get discovery about debtors' assets, things that you'll need to do to conduct a bankruptcy. That's why it's usually broader than regular standard discovery. However, because Wes Christian thinks he's clever, more clever than any lawyer that has ever existed, he is using Rule 2004 discovery to try and play this end round game to get discovery that he should not be able to get at this stage of things. So let's crack open this nut. As set forth more fully in the accompanying memorandum and points to the authorities, the subpoenas should be quashed because they are unduly burdensome non-party FINRA with requests for information pertaining to speculative potential claims that have not been filed, which information could be obtained from more convenient sources, and which information is irrelevant, unhelpful, privileged, and would otherwise pose an undue burden and significant expense to non-party FINRA. The non-party part is key here, because if you are a non-party to a litigation, you have no stake in the actual proceedings. So courts are supposed to protect you from extra harms that would be visited upon you, because like there's nothing here that has anything to do with you other than you're providing materials for someone else's case. So the standing is higher for getting discovery from non-parties than it would be if you were a party to the case. And there are more protections in place. According to the Securities and Exchange Commission, MMTLP, since former CEOs of its predecessor companies orchestrated an illegal short squeeze, they got right out the gate, guns blazing. The scheme, the SEC alleges, is complex. But in short, the SEC alleges that the former CEOs devised a scheme to issue a preferred stock dividend in connection with a reverse merger. The former CEO then spread a narrative to investors that short sellers would not be able to obtain the preferred dividend following the merger, thus pressuring short sellers to close their positions and artificially raise the prices of the company's common stock. The SEC alleges the scheme worked that way, and MetaMaterial's predecessor raised $173.5 million by selling its common stock into the inflated values shortly before the merger. The SEC's case against the former CEOs is currently pending. MMTLP settled with the SEC a year later. See, they're already starting by building the facts of this by saying they're getting ready to accuse people of market manipulation when the company itself already settled with the SEC and admitted to the manipulation. So they have strike one. Strike two, since there's already admitted manipulation, you can't accuse others of manipulation, because the whole basis is that you bought or sold in a normally functioning market. But if you create a short squeeze and create a non-standard market, like this is what happened in the case. It was SI versus Ryan Cohen, where because it was in a short squeeze, it wasn't a regular market free of manipulation. The market was in an extra state because of the manufactured short squeeze, the manipulation. The market was not acting in a normal function. Therefore, it makes their standard for proving that these other entities were manipulating the market harder to prove. At least under the, I know I should know the principle. I'm sure they'll get into it here, so I'll not linger on it too much for now. But they're already setting the foundation of, they want this discovery to try and accuse us of others of market manipulation when they've already admitted to it. So their fundamental thesis is kind of broken from the start. Approximately a month after settling with the SEC, MMTLP filed for bankruptcy. Yeah, that one's kind of silly, because, George Palikaris is a bitter asshole. If I can't have you, then no one can have you. Despite the SEC's allegations that MMTLP's predecessors made $137.5 million to an illegal short squeeze, the Chapter 7 trustee apparently suspects illegal short selling harmed MMTLP. The trustee has employed special counsel to investigate potential claims and, if meritorious, pursue litigation related to suspected stock manipulation through illegal trading practices such as naked short selling and spoofing. See, this is my big thing here, because I understand if you were a trustee, especially a U.S. trustee, in a Chapter 7 bankruptcy, you need to really explore all avenues just to try, because, who knows what money is out there. But this is a bit much. Even someone mildly professional, you would think you'd pull in the reins, bringing in Wes Christian, what? This has to make you the laughing stock of the Nevada U.S. trustee office. Michael Goldberg doesn't try shit like this. The U.S. trustees in every case that I've ever been on, now given it's usually been Chapter 11, but pulling shit like this, it's so weird. I'm baffled at what conversation led to this. The subpoenas are improper and must be quashed under Rule 45 for numerous reasons. As a threshold matter, it is axiomatic that subpoenas cannot be used for a fishing expedition to try and discover potential claims. Yeah, there are certain limitations on pre-action discovery, unless you're in Texas. Texas has this wild pre-action discovery thing where you can actually subpoena people and depose them as part of pre-action discovery. It's wild. Every other state is no, the only thing you can use for pre-action discovery is to find defendants and to preserve data that might be destroyed. So say, for instance, this is going back to the Crescente case from when they first tried to get the blue sheets in New York with Midwit Mark Bazile. When you're doing pre-action discovery, it has to be something that could be destroyed in order to get pre-action discovery. So say I have a security camera that's watching the driveway out there and everything, but it catches a car accident. they can pre-action discovery on me to get me to preserve the footage of the car accident, because it could get, over the course of time, wrote over. Because it's a security camera. It's supposed to capture things, and it's constantly, like, it's got a limited hard drive space. It could be written over. So pre-action discovery, make sure those files are secured for the future lawsuit that's coming. The other one is if you don't know who the defendant is, the plaintiff can file a pre-action discovery to find the defendant and identify them before you have your case. But you don't get pre-action discovery to go on a fishing expedition. That's not how that works. The subpoenas also must be quashed because they seek irrelevant information. A claim for illegal market manipulation requires damages caused by reliance on an assumption of an efficient market. So it's the efficient market theory. So the market is working efficiently. And as was discussed in SI versus Ryan Cohen, a short squeeze, if a stock is in the middle of a short squeeze, it is not an efficient market by definition. If it was an efficient market, it would be pricing in the value of the company. But as shorts are being squeezed out and the price is being pushed up, it's by definition not an efficient market. Or if the market is being manipulated, it's not an efficient market. So by admitting that they manipulated the market in their own stock, this whole efficient market hypothesis goes out the window. Yet MMTLP itself is already still charged with the SEC for allegedly manipulating the market through an illegal short squeeze by manufacturing it. SEC allegations that MMTLP and its predecessor allegedly made money through it. These subpoenas must be quashed for other reasons as well. Litigants cannot unduly burden non-parties with discovery requests that can be obtained from other parties to the litigation. Yet by seeking records provided to FINRA by the firms the trustee suspects of illegal trading, the subpoenas unduly burden non-party FINRA with requests that could be obtained from the firms suspected of wrongdoing. Because here's the thing. All of the blue sheet data that FINRA has, even the CAT, the Consolidated Audit Trail that they bang on about fucking constantly, you can get that from the brokers. Just subpoena the brokers. That's how FINRA gets the data. So you've already got the brokers. You already have the information. There is no need to subpoena FINRA. And this is the part that really just I don't get. They're already patting themselves on the back. Oh, we got the brokers to comply. Well, then you don't need anything else. That data, where FINRA gets its data is from the brokers. So you already have the information you need. Piss off. The subpoenas are improper for numerous reasons. The subpoenas impermissibly seek privileged and protected materials, including FINRA's investigative records that are protected by the investigative file privilege, consolidated audit trail data that can only be used for regulatory purposes by law, and attorney-client privilege documents. And the subpoena would impose a significant expense on FINRA, as responding to just a few of the 15 requests would require FINRA to collect and process and produce approximately 25 million records. Jesus. Wow. That's craziness. Okay. For all these reasons set forth in greater detail below, FINRA respectfully requests the court quash the subpoena pursuant to Rule 45, or in the alternative, issue a protective order pursuant to Rule 26 to preclude the discovery sought. We don't need the background. We know most of that. Argument. Subpoenas must be quashed because they unduly burden non-party FINRA. Rule 45 imposes a duty on parties issuing subpoenas to avoid imposing undue burden or expense. District courts must enforce this duty by sanctioning any party or attorney who fails to comply. Don't get too scary about sanction here. Sanction just means that if it costs the non-party something, then the party asking for the discovery has to pay for it. It's not like, ooh, you did something super wrong, so we're going to sanction you. It's just, you got to pay for their expenses if you're going to make it overly burdensome. And if you don't want to pay for those expenses, then you don't get the discovery. That's simple. As set forth below, the subpoenas must be quashed under Rule 45, or a protective order should be issued under Rule 26 for numerous reasons, including that subpoenas seek discovery for speculative and unverified claims, premature discovery that is barred by the SLRA, and we talked about that already, irrelevant information, duplicative or cumulative information that can be obtained from more convenient sources, and unhelpful information that is outweighed by the burden or expense to non-party FINRA. That's the key part of discovery. It has to have, like, it's a balancing scale between how helpful is this for the litigation and how much does it cost. If it's helpful a lot and doesn't cost a lot, then you're likely to get discovery. If it costs a lot and burdens the other party a lot and isn't really relevant to the case, then you're probably not getting it. And it balances back and forth depending on relevancy and how much it harms the non-party to have to do it. That's the balancing scale. The subpoena unduly burdens non-party FINRA with speculative requests to discover potential yet unfiled claims. That's the key thing here. Unfiled. If you want to sue FINRA, if you want discovery from FINRA, then file a lawsuit. It's that simple. And it doesn't even have to be against FINRA. You could still file a non-party lawsuit, but file it against the parties that you want to sue, and then you could seek discovery from FINRA. You still probably not getting it, but that's the correct way to do it. That's the legal way to do it. And if you're not going to do it correctly, well, then you won't get discovery. It's that simple. Courts routinely quash or refuse to enforce subpoenas seeking information for unfiled claims. ED from the case above. Okay, what was that case? NRE motion to compel subpoena to Department of Veterans Affairs. Okay. That the discovery might uncover evidence showing that the plaintiff had a legitimate claim does not justify the discovery request. Phillips and Cohen, LLP v. Thorpe, quashing subpoena for documents for use in a yet-to-be-filed lawsuit because the subpoena is a naked attempt to gather information for use in evaluating a potential claim. It is not appropriate, and there is no good cause to take third-party discovery, in this case solely to obtain information that will be used in another lawsuit. This court similarly refuses to permit any discovery that relates to unfiled claims and defenses. Claimant cannot lead a fishing expedition to find materials that might possibly become relevant to an as-yet-to-be unpleaded defense. Here, the subpoenas improperly seek to unduly burden non-party FINRA with discovery requests relating to potential claims. The trustee applied to employ special litigation counsel to investigate potential claims. Before the trustee has asserted claims, non-party discovery is improper. Yup. Oh, hey, there's Corsani again. Hi, nice to see you again. Been a while. Wow, actually not that while. 2024? That is right, I suppose. Bankruptcy Rule 2004 does not permit an end run around non-party rules and protections. This is a discussion that we had when we were talking about the other legal action. Remember, they were trying to get discovery against Fur2, Citadel, and Anson funds. And again, you can't use the discovery to do an end around. Hey, there's NRE Enron Corp again. Courts have expressed concern that Rule 2004 examinations should not be used as a tactic to circumvent the safeguards of the federal rules of civil procedure. While the bankruptcy rules may generally permit discovery relating to the assets, here's the key, to the assets and administration of the estate. That's it. Bankruptcy Rule 2004 expressly adopts and incorporates the protections for non-parties in Rule 45. Rule 45's mandatory prohibition against unduly burdening non-parties with fishing expeditions to discover potential claims applies to the improper subpoenas issued to FINRA. Yep. What's this here? When the trustee applied ex parte to examine FINRA pursuant to Rule 2004, the trustee nonetheless sought an order compelling FINRA to produce 3 categories of documents. But the bankruptcy court specifically denied the motion as to the document request. Oh, here we are again. So the same thing that happened when we were talking about the Virtu, like the subpoenas against Virtu, Citadel, and Anson funds, the court specifically denied the documents request because that's how 2004 works. I used to, on my old channel, have a bunch of bankruptcy hearings. How 2004 tends to work is it's like you're not, like, document production is not part of it. It's you get, like, say, the plan administrator on the stand, or you get like the CEO on the stand, or the CFO, and you ask them questions about the estate as the creditor or as a party in interest, like say a shareholder, and you ask them about things of the company that let them know about, you know, aspects that they would need to know about the estate to be able to determine their claims, determine what needs to happen in the proceedings of the bankruptcy. That's the point of 2004 discovery. The point is, of course, for parties that are to the bankruptcy. It's not for like non-parties. It's not to be able to discover claims against other people and then pull them into court. That's why 2004 discovery is so broad in a bankruptcy. Yet the subpoenas improperly purport to require FINRA to produce now expanded 9 categories of documents, well beyond the 3 categories the trustee sought from the bankruptcy court, yet did not receive. See, yeah, this is what's weird here, is like, then they suddenly expand what the discovery is about. Like, I sincerely hope that if this is Wes Christian and his cronies' little game, that they get sanctioned for it, because apparently Wes Christian has not learned his fucking lesson, and also he's not a bankruptcy lawyer and should probably stay the fuck out of bankruptcy court anyway. I knew the minute he weaseled his way into the Sorrento bankruptcy that this is the shit we'd be dealing with. Him and his blatant abuse of legal process, because it's what Wes does. I mean, the subpoena is unduly burdensome to non-party FINRA with discovery requests that are barred by the SLURA discovery stay. Under SLURA, the private litigation alleging securities fraud must establish the sufficiency of their complaint before they can obtain discovery. And as we know, they haven't even gotten to the filing the fucking complaint, so no discovery for you. The subpoena is unduly burdensome to non-party with irrelevant requests. The subpoena also imposes undue burden on non-party FINRA because the burden or expense of the purported discovery outweighs the likely benefit, as the subpoena seeks irrelevant information. The subpoena seeks irrelevant information regarding MMTLP. The trustee told the bankruptcy court that this is investigating claims for suspected stock manipulation through illegal trading practices such as naked short selling or spoofing of MMAT and torch shares. And there's your key right there. It was about these 2 things, which they have a right to do, but the MMTLP stuff, no, has nothing to do with what they asked about. These are not causes of action under federal law, but presumably would have such a theory of liability for market manipulation claims that are 9 or 10B of the Exchange Act. To state a claim for market manipulation, the plaintiff must have bought or sold a security due to manipulative actions. Well, we already know from the MMTLP, from the what we were talking about earlier, that since they didn't buy or sell MTLP, they don't have a claim. Also, these would be claims for shareholders, not claims. See, this is an interesting thing with all of like the spoofing claims that, and I guess share issuance. You could say maybe the company has a claim when it comes to issuing shares and claiming market manipulation, but generally as a rule, I don't know why more of these brokers don't like sit down and go, so Wes, you're doing these litigations on behalf of the company about spoofing, but the Exchange Act is specifically about like market manipulation from a shareholder perspective. So why would the company have standing? That's a question that I've never seen brought up, and I'm kind of surprised. Like, just the outright argument that the company doesn't have standing because, like, under the Exchange Act, these are things for, like, shareholders that are injured because they bought into a manipulated market. Like, where would you come up with that? Like, I think this is a pretty solid argument by FINRA, and I don't know why more of these brokerages haven't brought it up. Like, where do you derive standing for a company in a lawsuit like this? Unless I'm reading, the securities law wrong, which is potential. But like just looking at it, that seems logical. Where would a company have standing in this case? Here's discussed Super at 4. The SEC alleges Meta Materials and the former CEOs of Meta One, Torchlight, and Meta Materials, Berta and Palacaris, issued the preferred dividend, which later traded as MMTLP to create a short squeeze narrative. The SEC alleges that Berta and Palacaris promoted the narrative that short sellers would not be able to obtain the preferred dividend, thus pressuring short sellers to close their positions, artificially raising the price of Torchlight common stock. Approximately 18 months after the Meta Materials merger, the MMTLP shares were spun off into NextBridge, and NextBridge suggested, like Berta and Palacaris before it, the spinoff might trigger a short squeeze. Prospectus at 5. That spinoff was completed in December 2022. Meta Materials canceled the MMTLP shares prior to holders. Yeah, this is another one of the things I want to highlight because it pretty much makes clear that we have a second MMTLP lawsuit from the SEC coming. I really hope the DOJ tags along on this one. But yeah, not the end of this story. There's an even more clear one that Amy brought up. Like, we know there's another lawsuit down the pipe. And the fact that the MMTLP crowd continues to play hear no evil, see no evil, speak no evil is pretty fucking hilarious. We know who the criminals are. They're the ones getting sued by government entities. Like, it's 100% clear. It's kind of hilarious that they think that, like, anyone outside of their little cult doesn't understand what's going on here. That's why they've gotten rejected at the SEC. That's why they got rejected at FINRA. That's why they've been rejected in all the courts. That's why they've been rejected in Congress. Like, everyone knows where the problem is. The idea that everyone that like there's some conspiracy against them is absolutely silly. It is thus unclear and entirely speculative how Meta Materials could assert stock manipulation claims regarding to MMTLP. Meta Materials was not a retail investor who bought and sold MMTLPs. Yeah. Nor was MMTLP a common or treasury stock of Meta Materials. Meta Materials may have held some of the preferred dividend following to the reverse merger, but a holder of a security lacks standing to prosecute a claim under federal securities law. Yep. Nor is it clear whether or why Meta Materials itself would have traded MMTLP during the short squeeze that is a spin-off partner of NextBridge announcement might occur. Put simply, without specific allegations from Meta Materials and an actual lawsuit, it is entirely speculative whether Meta Materials could assert a private securities litigation claim related to MMTLP. Thus, when the trustee applied to retain special counsel to investigate potential market manipulation claims, the trustee did not even mention MMTLP. Instead, the trustee told the bankruptcy court it was investigating activities related to a merger in which Metamaterials acquired Torchlight Energy, both of which were listed on NASDAQ. This is the same reverse merger for which the SEC alleged Metamaterials and the former CEO engaged in the stock manipulation. Thus, there is no legitimate basis for the subpoenas to demand non-party FINRA to produce documents and testimony related to MMTLP. Subpoena seeks irrelevant information about MMTLP and Torchlight. To state a claim for market manipulation, a private plaintiff must allege manipulative acts, damage caused by reliance on an assumption of an efficient market free of manipulation. Oopsies. Scienter, in connection with the purchase or sale of the securities, furthered by the defendant's use of the mails or any facility of a national securities exchange. Those are your 6 elements to plead a case for market manipulation. And they already trip over the 3rd one. Because they've created this short squeeze. If they want to say that that's what's going on here, there was a short squeeze, then you already have an inefficient market. Here, it is entirely speculative whether or how Metamaterials could plead stock manipulation claims as to Metamaterials or Torchlight. The trustee had retained special counsel to investigate. Yeah, we got that. Specifically, Metamaterials consented to the entry of the SEC cease and desist order against it. That include filings by the SEC that Metamaterials raised $137.5 million in an at-the-market offering in which Metamaterials artificially inflated the value of its common stock by structuring a merger between Torchlight and Meta, specifically designed to cause a short squeeze. Having settled such charges, it is speculative whether or how Metamaterials could allege with particularity that it was damaged. See, this is the funny part about it. Pay no attention to the man behind the curtain. The suit we settled with the SEC. Pay no attention to that. Pay no attention to that. We were harmed and injured by manipulation we created. It's comical. It's sad. It's hilarious. In addition, Berta and Palakaris, the former CEOs of Meta One, Torchlight, and Metamaterials, are currently defendants in an SEC action alleging they schemed to manipulate the stock price. This includes allegations that Berta and Palakaris issued false or misleading statements and omissions about the preferred dividend in Torchlight, public filings and proxy statements, and aggressively used social media to promote the narrative that the short sellers would not be able to obtain the preferred dividend, thus pressuring short sellers to close their positions and artificially raising the price of Torchlight common stock. It is thus, again speculative, whether Metamaterials could plead that it relied on an assumption of an efficient market free from manipulation when the former CEOs are alleged to have engaged in such manipulation themselves. Oopsies. The subpoenas unduly burden non-party FINRA with discovery that can be obtained from more convenient sources. The suspected wrongdoers. That's a great title. Like, I think we can skip over this whole section here, D, because again, like, they could get all of the discovery they could possibly want from the brokers. FINRA has no data that the brokers don't already have. They ask for that data because it's their job to regulate the brokers. So you would be getting nothing new by subpoenaing FINRA that you could not already get from subpoenaing the brokers when you filed your action against them. That's simple. You want the blue sheet data? Subpoena the brokers. You want the cat information? Subpoena the brokers. Like, all this information comes from the brokers. It's that simple. Why it is so confusing to these people after 3 fucking years boggles my mind. They learn nothing learn absolutely nothing. The subpoena unduly burdened non-party FINRA with requests for information that would not be helpful. Not only are the documents and testimony the subpoenas seek irrelevant, but the massive amounts of data and records sought by the subpoenas would not even be helpful for the prospective claims, and what exists is otherwise publicly available. Whoopsies! The trustee has stated it is investigating whether specific financial firms or broker-dealers engaged in naked shorting or spoofing. And where were we? The subpoenas thus specifically and repeatedly seek records provided by firms, including broker accounts and details, but FINRA generally does not collect or maintain account-level data from member firms, and in many situations, FINRA collects data from clearing firms rather than the individual firms or broker level. For example, like that seems like really key here. Let's get all of that. Can you give me that? Thank you. For example, FINRA does not have data at the individual firms or broker level in response to subpoena request 1. In addition, FINRA already publishes much of the existing data. FINRA publishes data on short interest. Yep. Subpoena request number 1, seeking short interest reporting data. FINRA publishes short sale volumes reported through a trade reporting facility. So all the stuff there that they ask, it's already publicly produced. The subpoenas seek privileged and confidential documents. Courts must quash subpoena requests for privileged information protected by the investigative file privilege. The subpoenas must be quashed pursuant to Rule 45 because they seek information exempt from disclosure under the investigative file privilege. The investigative file privilege is based on the public interest in minimizing disclosure of documents that would tend to reveal law enforcement and investigative techniques. The D.C. Circuit has applied the privilege to the SEC's investigative files, and other courts have consistently held the privilege applies to FINRA's investigatory files due to the importance of FINRA's regulatory and investigatory functions as an SRO. To invoke the privilege, 3 requirements need to be met. 1. There must be a formal claim of privilege by the head of the department having control of the requested information. 2. Assertion of the privilege must be based on actual personal consideration by that official. And 3, the information for which the privilege is claimed must be specified with an explanation why it falls within the scope of the privilege. There you go. There's your pleading for that. Here, the investigatory file privilege applies. The subpoena expressly seeks all investigative records. Like, it's right there. Like, you don't get that shit. Records associated with any FINRA investigation concerning Meta or MMTLP. The subpoena request 6. The subpoena also seeks other internal FINRA records relating to FINRA's investigation. You don't get that. These are improper attempts to obtain privileged investigatory records. FINRA has submitted herewith a declaration from Stephanie Dumont, head of FINRA's Market Regulation and Transparency Services Department, in which Ms. Dumont asserts the privilege. As Ms. Dumont declaration makes clear, FINRA asserts assertion of the investigative file privilege is based on actual considerations by Ms. Dumont, who provides specific reasons the privilege applies. Specifically, the subpoena expressly requests investigative records arising from FINRA's investigations conducted pursuant to its self-regulatory obligations. Court must quash the subpoena request for protected consolidated audit trail or CAT data, which is pretty much the same sort of stuff. Subpoenas impose an undue burden on FINRA with requests for attorney-client privilege materials. The subpoena is unduly burdensome because they request attorney-client privilege materials. You don't get to request that stuff. It's, attorney-client privilege communications between me and my lawyer, you cannot discover. Also, things that are produced in preparation or for the purposes of a lawsuit or produced by my attorneys on my behalf are like the communications and all the research that goes into that, exempt. You do not get to discover them. That is attorney-client privilege. So it's not just me and my communications with my lawyer, it is the work product of me and my lawyer for the purposes of litigation or potential litigation. That's also a key one. If there's stuff that's being produced because of a potential or perceived litigation, also attorney work product. By the time FINRA issued the first FAQ on March 16, 2023, at least 3 separate litigants had filed lawsuits against FINRA relating to the MMTLP trading halt. The first MMTLP-related lawsuit was filed against FINRA on December 12, 2022. 2 additional lawsuits were filed in December 2020. Yeah, we remember all of these. Yeah, Hoffman, Tawil, man, good times. In light of the pending litigations, the drafting and preparation of FAQ was done by FINRA's attorneys. Thus, virtually every document and communication related to the preparation of the FAQs are privileged because they're client attorney records and their attorney work product. Subpoenas demand that FINRA wade through the innumerable privileged materials in a fishing expedition in the hopes that FINRA identifies some unprivileged materials that are relevant to hypothetical claims that have not been filed and poses an undue burden. Yep. Subpoena would impose significant expense on FINRA. Let me fix some things here real quick. Probably should have pinned that. Not like it's going to mean much. Oh, yeah. There we go. Subpoenas would impose a significant expense on FINRA. If a court orders compliance with a subpoena over a non-party's objections, the court must protect a person who is neither a party nor a party's officer from significant expense resulting from compliance. Which means that they can ask for fee shifting if things, See, this is the one thing that's like real interesting to me. When I think of fee shifting now, I assume that what goes into the fee shifting calculation isn't just the expense. Like, how burdensome and expensive is it to the particular person? Like, say for me, an expense of $3,000 is pretty fucking burdensome. That's like 2 paychecks. Like, that is burdensome to have to go through. But for like a company, an expense of $3,000 is that burdensome. But we also talked about like the Pulte v. Brandon Jones lawsuit when they were asking for discovery from Pulte Group and the records of going through the emails and redacting all that stuff. I think they said the cost was like $100,000, $150,000. So that was considered burdensome, and fee shifting was applied to Bill to have to pay those fees for having to do that. Because, like, you think of a company, $150,000, that's not particularly burdensome, but that's not a small chunk of change. If you were, like, a regular Joe Blow person, even a rich person, like, $150,000 is not anything to sneeze at. So, yeah. So, I guess the standard is, like, somewhere around $3,000 regardless of who you are. Which, I mean, I guess that makes sense. You got to have a flat standard that applies to everybody. So... yeah. If the court does not quash the subpoena entirely, then at minimum, cost shifting is mandatory to protect FINRA from significant compliance expenses. After all, they said, what was it, 23 million, millions of documents. At the beginning, they even said it was like 23 million documents or something like that. That's absurd. Having to go through all that stuff. Oh wow, I got a retweet from someone in the MMTLP community. That's shocking. A lot of those people just don't like me. Facts, they're dangerous. There are approximately 23 million, yeah, here we are, 23.5 million such records about just one company, or I guess you could say two when you're talking about the reverse merger. Like, that many documents, it would not be cheap to go through and have to pick things out, see what's privileged, see what's confidential, make sure it's all labeled properly, create a privilege log. Like this is not an easy task. This is laborious. Not just laborious for the people that have to compile it, but for the lawyers who will have to go through it, mark everything, and present that in front of the case. And you have to pay these lawyers to do all this. You'll have to pay them, probably an outside firm to come in and go through all these documents. That's what Pulte Group had to do. They had to hire an outside firm. It cost them $150,000. And I'm pretty sure it wasn't 25 million documents, because it was just a bunch of emails and a bunch of search query filters. So, like, I wouldn't be surprised if this was hundreds of thousands, if not millions of dollars to go through these documents. That is an unreasonable burden, especially for a adversarial case that you haven't even filed yet. Like, this is the part that, like at this point, that we're completely overlooking here. They're wanting all of this stuff to burden FINRA with all these requests while they're trying to regulate securities markets for a adversarial claim they haven't fucking filed yet. Oh, we're almost to the end here. FINRA presently does not know how much it would cost to produce the data responsive to all the 15 categories of requests, but the cost would undoubtedly be substantial. I would agree with that. I would agree that it would probably be substantial. To determine the cost to produce the internal documents and communications sought by the subpoenas, FINRA would have to identify the custodians who may have responsive documents, collect emails and records from all those custodians, load all those documents into an e-discovery database, and review the records for responsiveness, privilege, and personal confidential information, like what I just described. It would take months just to collect and load such recovery into an e-discovery database, and then an additional time and expense to review and produce those records. If FINRA is ordered to produce such communications and additional records, FINRA respectfully requests the opportunity to provide substantial information regarding the cost to the court for appropriate cost shifting. And remember, this is kind of complicated, because this is going to come back and they're going to have to submit this in the bankruptcy court. Judge, we would like you to approve a multi-million-dollar discovery effort against FINRA. What? What? Are you fucking kidding me? Like, to what purpose? Oh, you don't even have you haven't even gotten to like filing the claims yet, the adversarial claim? So you want me, a bankruptcy judge, to approve a multi-million-dollar expenditure that you don't know will go anywhere? Go fuck yourself. Go fuck yourself. That's kind of where I think that'll go. Especially since the judge didn't even approve this to begin with. That's another part we're skipping over here. The judge didn't even approve that, because that's not what 2004 discovery's for. Like, this whole thing is silly beyond belief. I don't even. But the next part of this, I'm gonna let the beginning part, it takes a little while for them to get warmed up. I've chopped up their like little space call that they did a little bit, and I'll probably chop it up more later to put for the Saturday show, but I just couldn't chop it up because there was just so much. Like, their live streams, especially in the MMTLP space, is concentrated stupid. Like, you know that old redneck comedy saying, you can't fix stupid. Stupid is forever. Well, that's this live stream. We should relabel this live stream the Stupid is Forever live stream. Like, just look at who all is in this group. Like, this is a who's who of idiocy in this live stream. We got Busy Brands, Junk Savvy, Softsit Curtis, Scam Investor, Frank Nez, Zieg Hale Michael, we got Jonah, Not Legal Advice. You know, he's off and on again, depends, but like I don't know if I'd hire him as a lawyer, and I don't know who Kevin B is, but this top two like 1.5 rows or 1 3/4 rows. This is concentrated stupid right here. FINRA's motion to quash MMTLP bankruptcy, transparency in jeopardy. No. The only thing in jeopardy here is that you idiots will have to face reality finally. I'm going to let this play, and I'm going to get an energy drink, and I'll be right back. Unless, you know, they say something really stupid and I have to pop in. I will preempt, to give myself some time, they're going to talk about how they're being... how they're being shadow banned. Yeah, okay, yeah, cool story, bro.
Hey, I just want to say that we are getting shadow banned pretty hard. I have not been able to post my own post all day today, and I know there's a couple other people that are saying the same thing. So we are asking everybody to spread the word to other communities. Now's the time for action and to make the calls to your representatives. Every ticker should be calling their reps to see how they can help us squash the squash or the quash. I tried to make it rhyme, but it didn't work. I need more caffeine. But that's all I wanted to say. Squash the quash.
Welcome. Obviously, our community is abuzz. Late last night, it was discovered that FINRA, in response to the subpoena issued by the bankruptcy trustee in the District of Nevada, Miss Christine Lovato, of course, we know there were 9 subpoenas that were issued. FINRA's was one of them. In addition to those 9 subpoenas, and I'll go over that list again for any of you that don't know, the judge also ordered all 9 of these entities sit for examinations and to produce documents as well.
Yeah, the produced documents part was rejected by the judge because the only thing that you're allowed to do for 2004 is set for testimony. Like, when you're in a bankruptcy hearing, usually what 2004 discovery is, you know, like I said earlier, you bring in like the CFO or something, and like the creditors will ask what's going on financially with the company, with the bankruptcy, how are things going, you know, the person administrating the bankruptcy, they'll like ask for testimony for pursuant to like a motion or something like that. 2004 is not a document discovery, not how it works. So, just to make that clear, because I guarantee you these idiots have not figured that out yet.
Wow. It's been a long time. It's been, 5 months? I believe that was the beginning of March. So it has been 4 to 5 months now, and no.
Yeah, because they've probably been talking back and forth before they filed this. That's how discovery works. You talk back and forth, you try and work things out, and if you don't, then you run into a filing like this.
No response from FINRA until now. Let me go over the 9 entities. Number 1, we have Anson Funds, who, if you believe the unsourced document, and of course...
if you believe the unsourced document, in other words, if you believe unverified rumors.
It was confirmed by John Berta.
Yeah, the master of truthful statements, and a guy being, you know, charged by the SEC. Yeah, I totally trust him.
Approached Greg McCabe asking for 10 million shares, which of course is far in excess of the 2.65 million that FINRA disclosed in their FINRA fact, which we have debunked more than once.
That you've debunked more than once. Yeah, I'll take shit that never happened for 500, Alex.
Then you've got 2 market makers, Citadel and Virtue, who together with Anson Funds just recently filed their own motions to quash. Then you've got 3 regulators. You've got FINRA, the DTC, and you've got NASDAQ. Now, up until this response, and I'll go over the details of some of the significance of this response and where it was filed, we had not heard a peep out of FINRA. We have not heard a peep out of DTC, but
like, that's how that's supposed to go. Like, you haven't heard a peep out of FINRA because, like, that's the process. Like, I don't understand. One second, I'm gonna adjust some things here. Because I think it's picking up more of the AC. I don't know. Maybe I'm just seeing things. Like, I'm looking at the volume control bar, and it's just like none of you are getting like a lot of background. Like the AC, you're not hearing that, correct? Just want to be clear, because it looks like on the bar I see that it's being picked up. But anyway,
I have said many times I expect them to produce their own motion to quash. And then you've got NASDAQ, who NASDAQ, as we found out a couple months ago, did in fact file and agree to a stipulated protective order. And so NASDAQ appears to at least be cooperating. Then you had the 3 brokers. You had TD Ameritrade, Schwab, and TradeStation. All 3 of those brokers, and additionally, Thinkorswim, which is now formerly owned by TD, now is owned by Schwab. TD is owned by Schwab. All 4 of those entities, 3 of them received subpoenas. All 4 of them have also signed stipulated protective orders. Now, guys, this is a securities situation. Whenever securities issues are being litigated and data is being turned over, it is typically, vast majority of the time, done under a stipulated protective order. You know, they cry things like, you know, private shareholder information, private company information, private, you know, trade practices, all that kind of stuff. So the fact that they did receive stipulated protective orders is not unusual and is not, quote unquote, a red flag, right? Also, we saw recently that the trustee filed a request of the court to allow her to go out and purchase additional data storage and management services. You don't do that unless you've got a load of stuff coming in. So again, my speculation, not
that it matter, not like, you know, that doesn't mean that it's going to be okay.
Attorney, this is not legal advice, though I believe
we got that
have
out.
an attorney coming.
We're moving from not financial advice to not legal advice. Progress.
That they are indeed turning over data. Okay. But like I said, in a very stealthy way.
How's it? I suppose she's going to get into her stupid theory here, but like, how's it stealthy? They filed their case in a court which has jurisdiction over them. Like, for instance, say if this was like a state dispute. I live in Kansas and Bronco lives in Texas. If he wants to file a non-party subpoena to get information from me, he can't just file it in Texas. Texas has no power over me. Like, a Texas court can send a subpoena to me, and I can be like, well, I'm a citizen of the state of Kansas. So, what you have to do is you have to domesticate the subpoena in Kansas, which means you need to go to a Kansas court and be like, I've got this Texas subpoena, turn it into a Kansas subpoena, and make him give me stuff. Okay? And most states, like Texas, again, is one of the weird ones. They don't have this, like, they haven't put in their legislation, their laws, like these like sort of interstate things where a lot of states now have agreed that if you get a state subpoena in from another state, it, you know, there's a process to domesticate the subpoena. But like, that's like, they're going to get into this stupid thing about how because the subpoena was filed and the opposition to the subpoena was filed in DC District Court that it's nefarious somehow. No. Like, these federal circuit courts operate in, like, federalism. It operates in the same method that the state courts do. Nevada court has no power to get a subpoena, even if it's a federal court, over someone residing in the District of Columbia. So the subpoena needs to be handled in the district court that has power over the entity. That's why they filed in the District Court of the District of Columbia, because that's the court that has power to enforce the subpoena if it's granted. So that's all that's going on here.
FINRA filed on August 6th a motion to quash the subpoena in the Nevada Bankruptcy Court. Let me read it. It says, memorandum of 4 points and authorities in support of non-party Financial Industry Regulatory Authority, Inc.'s motion to quash subpoenas, or in the alternative for a protective order. So guys, that is also, it's not just one thing, it's two things. So they're saying, okay, quash the subpoena or give us a protective order. But here's the interesting thing. They did not file it in Nevada court like Citadel, Virtue, and Anson, by the way, who filed jointly. That's curious. But
Not
they
really.
did not file
Okay,
in Nevada.
let's go. Let's break up the stupid here. Okay, first of all, if they wanted to, Virtue, Citadel, and Anson could have filed their motions to quash each in their own district courts, just like FINRA did. There's nothing nefarious about which way each one did it. They could have done it either way. You know, FINRA could have said, okay, I submit to the power of the Nevada court, I'll file my motion to quash there. They decided the DC circuit is what they were going to do. Virtue could have done the same thing. Anson Funds could have done the same thing. Citadel could have done the same thing. The reason Citadel and Virtue and Anson all did the same thing, because it was easier, especially since you're going to have to do a, oh my goodness, I know I should know this, a pro hoc vice. You're going to have to get local representation and file a pro hoc vice. That, you know, it's better to just have it jointly filed between the three of them and have the same pro hoc lawyer, the local Nevada representation, who knows Nevada law, to be your representation for all. That's why they file jointly. They each have their own individual in-house lawyers, but they file jointly because they have the same Nevada litigation. Oh, we got someone sneaking in. I gotta go ban someone off Twitter. Sorry, 1 second. Like, that's the one, or not Twitter, but Twitch. I hate, like, the amount of bots on Twitch. Goodbye. You are banned, sir. Do not pass go. Do not collect $200. Have a nice day. Anyway, so, like, it makes sense for them to basically file jointly. They all have the same claims, and it just makes sense to file there and file in that way. And the only way they can file jointly is to file in Nevada, and it preserves judicial economy. It preserves how much it costs for each of them, because they can all use the same fucking Nevada representation. Like, there's nothing nefarious about it. It's just smart. They don't have infinite funds to spend on legal bullshit. Your legal bullshit. So, of course, they're going to play it like that. That's just smart. That's good litigation. They don't want to waste their time with shit. But, of course, you know, junk stupidity has got to read bullshit into everything that happens because she's a conspiracy nutjob idiot.
Court. They filed it in Washington, D.C. court. It has a very tight timeline for response. So what we could potentially see here is a legal strategy to cost not only the bankruptcy and the estate money, because now they're going to have to...
Look, if you're going to file discovery pursuant to potential adversarial claims, you better be understanding what the cost is going to be to do those claims. If you aren't doing that ahead of time, you're a fucking idiot. So I don't know what Junk Savvy's talking about. If you've made a a cost analysis, to like the risk versus the reward of doing litigation. You've already thought of this. Like, what are you? Is this what people do when they're trying to pretend to be smart when they're actually an idiot? Because that's what this sounds like.
Seek local representation as the trustee's attorney. Jeff Hartman is not licensed to practice in the District of Columbia.
Sounds like a you
So they're going to
problem.
have to seek some local representation that may or may not be informed on this issue. Most likely, probably not informed. Not only that, it was done so on a very tight time schedule, right? So not only is it going to cost the estate fees, it's
Here's the problem. If you hire Pro Hoc Vice, yeah, you have the local representation there who's advising you on local law. That doesn't preclude the lawyers from the bankruptcy case making the arguments in the court. It's the whole purpose of Pro Hoc Vice. So this whole argument here is someone who doesn't know shit about law and is just making up shit on the spot, which is, I mean, par for the course for Junk Savvy. She doesn't know fucking shit.
also going to cost them time in a very tight time schedule. So this was issued on August 6th. They did not actually subpoena and serve Jeff Hartman, sorry, not subpoena, but serve Jeff Hartman until days later.
I mean, yeah, you have a window for serving someone. Usually, I mean, depending on what the thing is, it can be up to 14 days. It can be longer. So, boo-hoo. If the service was proper, if the service was proper, too fucking bad. Again, stuff that you think about if you're going to do litigation. I'm sure that the trustee, if they were going to do this, they thought about it, okay? This whole idea that, oh, they're trying to play illegal games, like, shut up. You're trying, like, all this is trying to sound smarter than you actually are. Like,
hearing for this right now is set for September 4th. What is the significance of that hearing date?
there's no significance, but she's going to make up significance, and then we're going to deal with her stupidity at the end of that.
So now you've got a hearing in DC set for September 4th.
Mhm.
You've got a hearing set Nevada set September 4th to hear the other joint motions to quash. And you've got Scott Trott's hearing where he is attempting to disrupt the bankruptcy process by removing West Christian, the trustee, and to have it restarted and administer the way he sees fit. So all of these things are going on the same day. And so I don't know if that's intentional.
Yeah, it is intentional, you dumb bimbo. It is intentional. Like, when you have discovery, you're all the parties are talking, they're having back and forth, like open discussion. It's required by the rules of civil procedure. Like, if I was suing Manuel, we like, if there was even discovery, say he's a non-party and I want discovery, we would be communicating back and forth until we reach an impasse, and then we go before the court. Like, this was all planned out ahead of time. The reason that, like Scott Trout was already going to be in there on September 4th. That's why the consolidated case also got the September 4th date. And it's why this one's going to get the September 4th date, even though it's in a different court. It preserves judicial resources. It preserves resources of the legal teams. It makes it easier for everyone to just put it all on the same day. Like, that's the point. There's, again, trying to, like, make up nefarious things that are going on in this court case when there's nothing nefarious about what's going on at all. Like, everything about a legal proceeding is planned for a reason. Even discovery. Like, the reason why you have depositions is so you don't play these gotcha games in court. Like, every part of a legal proceeding is done in a specific way for a reason. And that's what these conspiracy dolts hate about it. Because there's no way to play these, like, bullshit games like she's trying to play right now. Everything is done for a reason.
Or by design. Also, by filing this in DC, could they potentially be looking for a FINRA regulator home base territory
Oh,
advantage.
Jesus.
Or possibly, is it also, as I speculated this morning, potentially a dog whistle?
Proceed with the stupidity.
We are very loud about our outreach to Congress in Washington.
And Congress has been pretty loud about how they're done with your dumb shit. Like, so very fucking done with your stupidity.
In DC, and other sources in DC. And so, is this potentially a dog whistle to those in DC? Some sort of warning, say we're not okay with this. I know that it addresses specifically issues about the CAT system, which is very controversial in DC. So again, was this a dog whistle to rally support around those that object to the use of the CAT? So it could be a lot of things, guys, but that's kind of an
It could be a lot of things, but I can't prove them, but I'm going to speculate them anyway because it makes me feel better and smarter in front of people when I actually know nothing.
Introductory of where we're at and why we're here. Curtis, good morning. Good afternoon. Welcome to the mic.
Yes.
Oh, God. Somehow we got stupider all of a sudden.
Thank you, Savvy, and thanks for hosting Busy. An important milestone that was pointed out earlier in the space that I was not aware of, but fortunately our community is on top of everything and was already preparing some activities for September 4th, unrelated to this. September 4th happens to be potentially a landmark decision, specifically on the consolidated audit trail usage front. And FINRA's defense here is specifically that there is no legal precedent for use.
It's not that there is no legal precedent. It's that by statute, you don't get it. Like, period. By statute, as they said in their filing, the CAT is not for private litigation. It is specifically for government investigative purposes. You don't get it. That's how that works. Like, whatever.
Of this, and it is a utility that's reserved for the financial regulators.
Yeah.
And the problem with
law.
Is the same problem that we have holistically, which is, first of all, the consolidated audit trail that acts as...
Like, calling them all-stars, Vent, is giving them far too much credit. They're not they're S-tier morons. Let me meet with you. They're S-tier morons. Like, all these people are talking about shit they don't understand or don't care to understand and then trying to pretend like they're somehow smarter than everyone else.
The soup to nuts, end-to-end transactional paper trail that exists on every single loan or every single stock transaction that exists, it's there specifically for this purpose, to provide transparency where needed, to act as an enforcement aid, and for visibility in identifying any kind of manipulative practice that might occur. But the problem is it is owned by FINRA CAT LLC. It's rolled up direct.
I mean, FINRA administers it, but it's by grant of Congress.
Through FINRA, who is, of course, a self-regulatory organization governed only by the SEC. That's on paper, not in practice. The SEC has obviously failed in their duties of
according to you,
holding FINRA accountable for upstanding to their own rules. So this is an extreme conflict of interest, and the reason I bring that up is because
according to you,
this has much broader impacts than just the MMTLP, metamaterials investors, previous Torchlight investors. This is
according to you,
much broader. This sets precedents for future manipulation inquiries, and that is very important to
again, he's talking about precedent. It's not a matter of precedent, it's a matter of on the books law. We're not talking about case law, we're not talking about common law, we're talking about actual statute. CAT was and is only allowed to be used by the regulators. That has never been in dispute. There is no precedent. That is what the law says. Like, how is this fucking hard to understand? How?
All of the investing public, retail investors, issuers, heads of company alike, anyone that invests in public markets should have a vested interest in this, because where there has been evidence of significant market manipulation, you have the regulator that's supposed to stop that from existing, that has for more than 2.5 years avoided any level of transparency. And now you have this
According to you,
landmark case, this landmark opportunity to
it's not a landmark case. It's not precedent setting. It's fucking...
bring all of these parties accountable, and FINRA comes as...
Man, I wish Chancery Daily was still around so she could, like, share this pain with me, because, look, I'm one of those people, like, if I have to lose brain cells listening to this, someone has to share this agony. And I'm sorry, Chance, but I feel like... I know you're Delaware law and this is federal law, but still, like, this is dumb. Like, unbelievably dumb. And I need someone to share this agony with me.
a non-party and tries to quash any level of transparency in any of the data utilities that would be there to prove or disprove market manipulation. That's very important.
Well, and there's something else, Curtis. I put this in our discussion group a little bit earlier, is via a pass-through, the CAT and Blue Sheet data is actually funded by retail investors, right?
Yeah,
people,
just like
we discussed
everything-
this many months ago, that people were starting to see these fees.
She's about to go into the thing that, herder, we pay for the cat. Entertainment, man. Like, sure. Like, in the same way that rubbernecking a car crash is entertaining. But at the same time, man, do I feel like my brain cells are slowly seeping out and dying. Like, the reason why I'm using intoxication right now is the fact that I'm trying to, like, you know, some brain cells are gonna lose this fight. Like, we know that alcohol kills brain cells. But, like, that is a risk I'm willing to take, because what brain cells will die, many more will be preserved from the stupidity by being blind, stinking, fucking drunk. Like, I don't know. It is entertaining, but, like, some of it is just, I can't. I just can't. It's like being assaulted with stupidity.
Fees show up on particular transactions, blue sheeting and CAT administration fees. So here we are as retail investors being assessed fees, even if they are just pass-through fees.
It's no different from taxes. There's things about the government I disagree with. I still have to pay taxes. Like, what are we even arguing about at this point? This is dumb. This is really dumb. For real.
Or these investigative tools that are then being gate kept by the regulators, and we're not allowed to access them. But what this allows the regulators to do is operate in the shadows without accountability and without oversight, because they are also denying this access, specifically with MMTLP, to their oversight, which is Congress, House Financial Services, and Senate Banking Committee. For 2.5 years, they have denied those
Yeah, because they're allowed to when they're, like, conducting an investigation.
Oversight authorities their job, right? So what this allows these regulators to do, like I said, they operate in the shadows, they selectively enforce, and then,
according to you,
and have zero accountability when it's potentially demonstrated that they were, negligent in their own responsibilities.
According to you.
But even further than negligent, actually conspired to protect the criminal manipulation in the market.
Citation needed.
Which our FOIAs
have
now demonstrated they in fact did. Not just FINRA, but also the SEC. And again, that goes back to the dog whistle that I spoke of, Curtis, we have got these guys on the ropes.
Sure. Yeah, you got him on the ropes, all right. The law is squarely in their favor, but you got him on the ropes. Yeah. Okay. Cool story, bro. Big if true.
And they know it. They listen to our calls. They know what they're doing. They have contact.
What kind of like main character syndrome do you have to think that like FINRA officials at FINRA are setting into your space calls and listening to them? I can't even fathom that. Like the idea that some government organization is so scared of you that, like, that is so epically fucking dumb. I don't even, I can't even. That is just so.
Acts in DC. This was, to me, even though it is disguised as a routine filing.
What do you mean disguised as a routine filing? We just went over it. What part of it is hard for you to understand? No, I get what's hard for you to deal with because they brought actual case law and it blows up your stupid worldview. But like, what substantive arguments against their case law? What substantive arguments do you have to defend the plan administrator shit? I'm thinking about the Bed Bath & Beyond bankruptcy at this point. The trustees 2004 discovery. By law, it's not allowed. So much so that the court modified it before they sent it out. And then the trustees' lawyers remodified it to try and fucking... I swear they live in a different reality from everyone else.
It really is an act of desperation. They're like...
Protection much?
Is on the line as an organization, and they know it, especially if you know this administration, the connection to what section is it in Project 2025, Curtis? 19?
Financial? What? No, it's yes, it is. I'm sorry.
Is it section 19?
Wow, we're getting into Project 2025. Like, everyone get your QAnon hats on.
It is. I was focused on another chapter.
Sorry. I can't even
goodness.
believe I remembered that. But anyway, so there's more to this. This is obviously layered, but
All right, you guys, make sure to have 911 on speed dial. I might get alcohol poisoning just trying to get through this. We're only 13 minutes into this fucking... Okay. This is an administrative decision. We're moving this up to 1.5 speed.
And I see Richard Hoffman here, so I sent this to Richard so that he could take a look at it as well. But guys, as we continue this discussion today, you're going to have memories and shades of the arguments in the Khorassani case. They basically have regurgitated those same arguments.
Because those arguments aren't any different, and they're the same arguments, and they're perfectly justified. Oh, they're regurgitating the Khorassani arguments. Yeah. Because they shut you down last time, and they still have bearing and precedent. Like what?
And why would they not? They apparently worked, but let's...
Oh, I'm glad you can admit that. Thanks. I mean, fuck.
Hope that the trustee and whoever they choose as local representation, as well as the judges, do a better job than in the Khorassani petition.
What better job could they possibly do? The law is the law. Like, I remember seeing this, like, post that someone made of this, like, whole crowd of people, and they had MMTLP over it. And then they had the one person, and they had FINRA, and they said, I think you're wrong. Well, yeah, that's how the law works, dipshit. It doesn't matter how many thousands of blithering fucking idiots think someone is wrong. The law says this is the law. And unless you want to go petition Congress and change the law, that is what the law says. You can say all you want to that the sky is fucking green. Anyone with a brain cell can look up and see it's blue. So it doesn't matter how many blithering idiots you convince that the sky is green. The sky is blue. Get over it.
Hey, Sally, before we go to hands, can you please read George's post? And then, Frank, I sent you a text. If you could please reply, and then we could go on to hands. Thanks, Abby.
Sure. So up in the nest, guys, and I'm reading it for the first time myself. I was actually sorry, guys.
Oh, boy.
But George Valicaris posted, FINRA's motion to quash was expected, but I have to admit it is hilarious. Beyond the twisted lies and throwing in the kitchen
Projection much over there, George?
sink in utter desperation in this dock, the
Projection again.
fearless self-regulator just sprinted past the Nevada bankruptcy court straight to the DT's arms.
Again, the DC District Court is the one that has jurisdiction, they reside within the DC District Court. That is where the subpoena is dealt with. They can choose to forego and have it in Nevada, just like Virtu and Citadel and Anson did, because they wanted to file a joint motion to conserve legal resources. But FINRA said, nah, if you want to get discovery from me, a non-party, you're going to do it in my house. And I don't blame them.
Running home to DC makes sense, I guess.
Running home to DC, no, that is the legal process. If you were to send a subpoena to me, it would have to be heard in my home state. That's how that works. It's not running home. It is the legal process, you dumb cunt.
It is where the emails and trading data are archived and their supporters know which files not to open. FOIA's gave us the receipts, Nevada has the questions. Nothing says confidence in your position like running to daddy.
It's not running to daddy. It's no different, again, than if you tried to subpoena me. You have to file the subpoena in my home court, in my home state. It is no different in federal court. If you want to subpoena me as a non-party, that subpoena must be in my home district. End of story. The rest of this is just fucking masturbation on social media.
When the grown-ups start asking questions, hashtag.
You are not the fucking grown-ups. Let's get that straight. You are not the fucking grown-ups. You are the kids coloring on the fucking wall with crowns. That is what you are.
Hashtag FINRA. Funniest part, the only thing they are self-regulating is how fast they can run.
Yeah, it is my reactions because just like, again, I feel like I'm being assaulted with stupidity and I must challenge how fucking stupid this is. It's ridiculous. This is just... Like, it hurts even worse when you deal with the law on a daily basis and you watch these clowns fucking, like this is what you do day in and day out, and these clowns are fucking, like, just... It's a travesty.
From real scrutiny while trying to limit the narrative to MMTLP as if this was a one-off event. The difference between us is I welcome scrutiny. Now run to your
No, you don't. George, shut the fuck up.
daddy. Please ask for this for me to make all MMATF, MMAX, MMAT, Torch, MMTLP company emails sent to and responded to by FINRA and the OTC publicly available, just like you did with NBH, showing a fraction of the real communications leading to the merger, period 1, the start of the MMTLP, period 2, and the MBH spinoff, period 3. Your failures are continuous, pre-merger, and transcend one issuer. It is widespread. We have all the receipts. Let's see which of your clients, members, are behind the systemic market manipulation, especially surrounding the OTC markets. Perhaps start with the ones on the UPC committee during the relevant period. You know, the ones who've magically vanished from view. On a serious note, I don't know if you guys can sense this sarcasm, I certainly do. On a serious note, FINRA is the only entity holding consolidated data.
Yeah, I've become to the conclusion that sarcasm is the tool of idiots who are trying to disguise how stupid they are.
Across all brokers and venues, more efficient than broker-to-broker subpoenas. This case represents a watershed moment for market integrity and regulatory accountability. FINRA's motion to quash is not.
Absolutely not. This is a watershed moment in fucking stupidity on the road to fucking idiocracy.
About protecting legitimate regulatory interests. It's about concealing evidence in one.
No, it's about how close we are to the idiocracy being real life in financial markets.
One of the most sophisticated market manipulation schemes in modern history. One that has cost the metamaterials estate billions.
Yeah, you were the manipulators, as we've already established. Like this is what's so funny about this. You, George, are one of the manipulators, and you're trying to like play pass the buck and trying to confuse everybody. You were one of the manipulators. You and John were the manipulators. Like, it doesn't get any more clear than that. But you got this whole cult that follows you around. You got them all confused. Well, good for you. You can confuse some of the people most of the time. But the rest of us over here in reality know exactly what you're about. And your time will come.
Millions of dollars while enriching the very firms that sat on FINRA's boards. You cannot run from this. Fix it.
Yeah. Projection much?
Pretty feisty there, George.
Yeah, you would have to be pretty feisty considering you're looking at charges that would prevent you from... Luckily for you, they're not DOJ charges, but would bar you from being part of the board or an officer of any company if you were found guilty. You just wait.
Yeah. But no, I mean, guys, he's absolutely right. There's a reason that they go venue shopping.
It's not venue. It's not venue shopping. Again, you dumb cunt. You fucking bimbo. It is not venue shopping. If you file a subpoena against a non-party, it has to be directed into the venue that has jurisdiction over them. Same if it's a state court, same if it's a federal court. You can make the choice to respond to it in the court it came from, but that's a choice. It's not venue shopping. Come on.
You know, and they could have filed in Nevada and quite.
Yeah, sure. Cool. They could have filed in Nevada. Of course, you want them to be the one taking on the expenses for filing their frivolous nonsense. Again, Virtu, Citadel, and Anson wanted to file jointly. That's why they filed in Nevada. That was the only way you could file jointly. It conserved legal resources for them. FINRA is filing on its own, separately. So yeah, it's going to pick the venue that it's in and make you come to it, as you normally would have to do with a subpoena.
Frankly, when we look at the arguments, you know, Curtis, you talked about that this morning, is they're trying to have it both in all ways.
Why is it always projection with them?
Right? They're trying to say you can't do it because of this, but then you can't do it because of this, you know.
That's the whole point of a legal filing, to cover all your bases, to present all of your arguments, because you have to in your opening filing. When you are the movant, you have to give all of the plausible legal reasons. That's how that works. I'm sorry that you've never had to file one of these. I had to because Bill Pulte tried to fucking subpoena me. That's how it works. You file all the possible arguments. Of course, you're going to pick the best arguments to present, but the idea is to cover all the bases. Of course, that's what they're going to do.
And it's definitely some circular logic that I'm sure we're going to break down here in a little bit.
Oh, sure. Cool. Okay.
But one of the big themes that George brings up in his post is the SEC and the enforcement actions against George and John Berta were very strategic in
How?
limiting the time frame of the enforcement action.
When you file a litigation as a plaintiff, you get to do that. When you create your claim, you list the things that happen, and you list when they happen, who did what, when, where, and how. That's how a petition is structured. That's how a complaint is structured. Like, that's the things you get to do when you're the plaintiff. This is such an absolutely willful misunderstanding of how the law operates. And I have to say it's willful because this is such a fundamental element of the legal process that you would have to have either put a bullet in your head and removed part of your brain in the process to be this stupid. It has to be willful. This is the things you get to do with the plaintiff. You get to structure the claims. The time period, who, what they did, how it affected you.
So as to limit potential discovery of MMTLP.
Oh my.
But now you've got FINRA who's extending that timeline and conflating all of this.
You are the ones who extended it again. You were the one, like the state is the one who extended that timeline. They're the ones who originally it was only about MMTLP and Torched, and then as was pointed out in the discovery, and even with the discoveries with like Citadel, they kept expanding it. And I like to, like, in my mind, I had the image that it, like, the trustee, and maybe this is just me being hopeful, the trustee doesn't know like 50% of what's going on here, maybe more. Because, like, we saw it with Citadel, and we saw it with Virtu and Anson, how they talked about in their exhibits and in their filings how this discovery kept ballooning. Like, they kept expanding it. That was not FINRA. That was a choice by the petitioners of these discovery motions, the estate for metamaterials, and potentially the U.S. trustee. Or at the very least, the lawyers that the U.S. trustee hired. Like, this was a legal strategic decision. But, of course, they're trying to, like, change around who's responsible for this and push it off on FINRA because they don't want to have to deal with the responsibility that their side legally keeps moving the fucking goalpost.
To MMTLP as well. And as we know, guys, in the bankruptcy, they are specifically pursuing claims of spoofing and market manipulation, spoofing in particular and naked shorting that we all know that the CEOs have nothing to do with. There
Citation needed? Like, should I even say it at this point?
is not a market mechanism that allows them to do that. And so this is absolutely distraction and deflection and
again, it's not FINRA that keeps expanding the discovery, it's the estate.
inflation on behalf of FINRA, but we don't expect any less.
I don't expect
Curtis,
any
before
less
you
from
go, Frank Ness and Richard Hoffman are having.
Oh, Frank Ness. Oh, I'm ready for this. Oh, boy.
Connectivity issues, so I'll
Like, I haven't even gotten to this part yet. This should be fun.
keep on resending them the mics. In the meantime, go ahead, Curtis, and then we'll go to Michael.
Yeah, I think obviously I know the intent is to get into the specifics here in the motions to quash and this one specifically from FINRA. But I think the important takeaway, I already hit on the first one. This applies and affects far more than just these investment communities. It affects
No, not really.
all of investing public. So Everyone has a vested interest in this outcome and should be extremely outspoken and escalate wherever and whenever possible. Time is of the essence. That's first and foremost. The second is, and I know we're going to get into the details of breaking this down, but overall, what FINRA describes as burdensome in providing this data, I think it's very important to pick that apart, and I'm sure.
Good luck with that. One sec. I'll let this go because
The
I'm
legal
sure this is
teams
going to be.
will do just that. But it is important to note that electronic blue sheets are a pre-configured, pre-prescribed format, that those requests are responded to in less than 24 hours when FINRA or the SEC initiates a request. It's also very important to note that via Freedom of Information Act requests that have been granted all the way back, and I see Howard is actually in here. We have an investor that.
Yeah, and we already got the information from that FOIA. The FOIA said that they thought the issuers were the criminals involved. That point from that FOIA that you guys keep trying to skip over and pretend doesn't exist.
That through his persistence got the first milestone breakthrough FOIA back in really the end of March of 2023, just a few short months after the U3 halt of MMTLP. But those communications revealed that FINRA and the SEC were actively blue sheeting, meaning they were already pulling much of this data.
But again, it's a method for law enforcement. And also, again, that ignores the point that they already made. All this information is available from the brokers. Where do you think they get the blue sheet data from? It's the thing that, like, FINRA's been saying, and I've been saying since the start of this. Just subpoena the brokers.
That they're saying is overly burdensome. So they're literally pointing out and saying that it's going to be a burden for them to pull data that has already been pulled. The level of effort and expense associated with pulling this data is minimal because, again, it is pre-configured. It is a static format. And this is a normal business as usual request that
Like
comes with any
that's
pending
that's
import.
an assumption that you're making. Do you know that for a fact, Curtis? Or are you just making shit up just like Junk Savvy? I'm going to go with that you're just making shit up and you don't actually know.
Or investigation action. And they're acting like this is a new request, that they would have to go generate records, and that this is not already part of a normal record retention and examination process, which it absolutely is. And the last piece is the consolidated audit trail is automated. It's not by request. Electronic blue.
Citation needed? Like, according to you, do you actually have proof of that? Or is that just, like, shit you're making up? I get the feeling it's shit you're making up.
Blue sheets are generated by request, meaning FINRA and or the SEC has to generate a request to broker dealers and or clearing firms, all the relevant parties, and then those requests are supplied through one of three mediums. Again,
I'm glad you admitted that they came from brokers, which means you can get the blue sheet data. All you have to do, like FINRA said, if you had read the motion to quash, is you can get all this information from the fucking brokers. Like, again, I get the distinct feeling none of these people have actually read the motion to quash that they are actively commenting on.
Generally within 24 hours. There's an escalation process if it could not be provided for whatever reason, but generally within 24 hours or less. Consolidated audit trail is automated. That's why it's consolidated, and it is an audit trail, and that is why it has been fought tooth and nail for over a decade for implementation. And
yeah, and it's for regulatory purposes only.
last summer, we just hit a milestone in a very key phase of implementation of the consolidated audit trail. And there is no coincidence that we saw the most noise from firms like Citadel and Virtu, that not only was the cost overly excessive and they challenged the funding model, and I don't need to tell you, but their balance sheets say that they could absolutely absorb the cost for that. But and as Savvy pointed out, almost every cost is passed through to the end consumer. So that's a farce on the surface.
Yeah, but again, does the insert like this goes back to taxes and the same things that we talked about with tariffs. Like, you know, okay, cool, that gets passed on to the end user, true, but does the end consumer want to
pay for that? Are people changing services because they don't want to pay for that? Is like again, wild assumptions that Curtis wants to make, and not even trying to defend, FINRA wanting to get rid of the cat, because I am indifferent to the cat. Like, I haven't seen any meaningful changes in my prices working at Fidelity, but like, they're legitimate things to consider. Like, does the cost of what's going on actually outweigh like the information and actual regulatory function? These are legitimate questions that should be asked. Could Virtu be right? Sure. Could Virtu be wrong? Sure. But like, their assumption that Virtu said this thing, so they must be wrong, is idiotic, and it should be rightfully called out as that. Because again, it's a cult who already has a pre-assumed conclusion.
And I think what it truly reveals is there is an extreme concern already that the regulators would have access to this data, but that anyone else that would be wanting to bring attention to market manipulation.
No, the concern is that like the amount of data is like, especially when you talk about like let's look at this honestly as opposed to soft-sit Curtis here and his idiocy. We live in a digital age where like you see hacks happening all the time. Like, we just got done, like one of the major news topics is that the current judicial like Pacer and all the back end information just got hacked by potentially Russia. Okay, so you want to consolidate all of this financial information about people's brokerage accounts and their brokers and everything in one spot? Like, that is the juiciest fucking target ever if I was a hacker. Like, that is a legitimate concern. And not saying that doesn't mean that the cat shouldn't exist, but the protection of that information and the idea of looking at this as a concern that all this information is in one place, centralized, that someone who just, like, the endless struggle between hackers and the people trying to make protections, like, this is a legitimate concern. And the fact that he's just hand waving it away like it's nothing, this is nothing we should be concerned about, is just emblematic of the meme stock group in general. Anything that might be a concern to their narrative is just disregarded, regardless of how important it might be to actually consider it, because it might go against like the cult and its groupthink. Don't even think about that. You're not allowed to think about that.
That they would have access to this data, and it is automated. There is no burden in providing the data because it's already provided. This is all part.
It's not a matter of the data exists. Like, again, they still have to compile it. They still have to go through it and see what parts of it needs to be considered privileged. Because again, it is a trail for regulators, so it may be completely and totally exempt from discovery in a private litigation. And even if it was discoverable potentially in a private litigation, you have to put the parts of it that are like, you have to classify it, or parts of it that might be exempt, and then you have to group it together. And then you need to create a privilege log, so that way, if you want to challenge the fact that it was marked as privileged, we can have a discussion about that in front of the court. That's all time, money, and resources to create a privilege log, to gather and present all this information, even if they already have it accumulated. Like, the fact that this idiot is just, like, completely glossing over this. Curtis has not fucking read the motion to quash. I guarantee you, he has not fucking read it. Because he would not be making these stupid fucking arguments that were spelled out and definitively responded to by FINRA if he had read the motion to quash. This idiot has not read it. I guarantee you. Curtis, feel free to prove me otherwise, but he has not fucking read the motion to quash. Guarantee you. Not read it.
Part of a record retention policy well within the time frame that's being requested within subpoenas. So there is no burden. The burden, what is overly burdensome, is what FINRA and the SEC have chosen to take a stance and avoid, whether...
I love how these conspiracy theorists always flip the burden of the argument onto other people because they can't answer questions that are being asked to them. Always. 100%, all the time.
From a congressional outreach standpoint, from a FINRA standpoint in court and providing back responses to open letters and denying FOIA requests, they have fought tooth and nail to provide any level of transparency. And
well, unless they communicate with the SEC, FINRA is not subject to FOIA because they're not a government agency. And second of all, FINRA is allowed to reject them if it's part of an ongoing investigation. And if you read FINRA's response in the motion to quash, there are some very key hints in there that there's an ongoing investigation. And SEC versus BERTA 2.0 is on the way for the whole MMTLP shenanigans. And I hope that it isn't just the SEC, that we will be seeing United States v. BERTA, because that's what really needs to happen here to end all of this. Not just SEC versus BERTA, but United States versus BERTA, because that's when we know the DOJ has arrived. That's what ends all of this stupidity.
the expense associated with that fight to avoid transparency far exceeds any level of burden on already existing reporting and data.
Citation needed.
Hey, Curtis, and Savvy, I don't know if you got my message. Frank has a hard out at 1 p.m. My time. And then also Richard Hoffman, I believe he's limited on time. So, Michael, I'm sorry. Let me go to Frank first. And
They skip over Michael. Yes! Yeah, we didn't want to hear from fucking ZKL Michael anyway.
then we'll go to Richard in case.
Well,
Frank has
really
any
busy.
questions
Give me
for
30 seconds. 3 things on Curtis's
Right.
point. Number one, that recording of John Reed Stark is up in the nest, guys. Thank you again to Methuselah for grabbing that.
Who?
Number two is that FINRA and the SEC have already aggregated a large portion of this data because they have been investigating.
Again, so what if they've aggregated it? They'd still need to go through and process it, create a privileged log, determine what part of it needs to be classified, determine
Since 2019. They've been
look. So what if they have it aggregated? That's only like the half of it. Like not even half. Like I have already an aggregated record of my fucking Discord chats. They're right there in the log. All I do is scroll up on Twitter. But that still doesn't negate the cost of me having to go of my time or potentially like say on my corporation. So what if I have the emails already aggregated on a server? There's still the process of having to go through those and determine which need to be classified, which need to be put in a privilege log, and going through those and compiling them and then presenting them as like you're missing so many steps to this process. And again, it just shows that none of these cunts read the fucking motion to quash, or they'd understand this.
Investigating Atlas 8. They started the investigation into John and George. There was a previous investigation. So the idea that they don't have this data and they have to aggregate it, they've investigated for a very, very long time. And I forgot the third point. So let's go to Frank.
Frank dropped down again. Connectivity issues. Let's go to Richard Hoffman. Frank, I sent your mic again.
Hey, hi. How are you?
Hello, sir.
Yeah, hello, sir. Yeah, so I'll give you my quick take. I did read it I spent about 6 minutes reading the motion. I didn't read any declarations. So here's how I see it. One, it's completely expected and there will be no reason for them not to do it because they have nothing to lose. Absolutely nothing.
If you have nothing to hide, you just give it up to the cops. You have nothing to hide. You have nothing to worry from the police.
So I don't think it's a big deal, for starting off. It's completely expected, so if it's completely expected, it should not be a surprise. It shouldn't be a big deal, because it's not. And I'll get into the substance of it in a second. So the question I have is, the DC Circuit does not have exclusive jurisdiction over FINRA.
Yeah, they do. Well, I mean, there's 2 districts that have exclusive jurisdiction. Delaware and DC. I could chose either one, but, you know, they chose DC.
So I wonder, and I don't know the answer, I'm just throwing this out. I don't know if that circuit has jurisdiction in this matter.
They do.
Why wouldn't the bankruptcy court have jurisdiction over a subpoena that was issued?
They don't, because, again, it's a non-party subpoena. Oh my goodness. Is this Frank Ness? Is someone who's listening to this live stream now, did they listen to the original Space Call? Because I just kind of ripped this. I didn't want to have to, like, deal with this on Twitter. Is this Frank Ness? Because if this is Frank Ness, he is fucking stupid. Like no, the Nevada court does not have jurisdiction over an entity that resides in DC and is incorporated in Delaware. Not a ghost of a fucking chance.
At the bankruptcy court. So that'll be the first thing that popped in my head. Second thing, if in fact they filed this motion in DC, why doesn't the trustee file a motion in the bankruptcy court to compel those documents?
Because they can't. Because This has to be Frank Ness, because this is so fucking stupid. I can't even. Like, again, if same as, like, the federal district courts are the same as federal courts. I mean they're federal courts. Sorry, alcohol talking. Same as like state courts. Say, for instance, like in the Bill Pulte case, he's in Florida. I'm in Kansas. If he wants to subpoena me, he has to take his Florida subpoena and domesticate it in Kansas, and then he can subpoena me. All right? Kansas court has jurisdiction over me. Florida court doesn't. So he has to take the subpoena to Kansas, domesticate it, so a Kansas court can have power over me to do the thing. Okay? FINRA is not a corporation that is incorporated or has its headquarters in Nevada. It does not do business in Nevada, so much so that it would be at home in Nevada. Okay? Clear? We clear on this? So, the subpoena has to go to the DC District Court, where the HQ is, or the Delaware District Court, where the company is incorporated. Pick or choose. So, it was sent to them. They brought it up to the DC court, the federal district court that has jurisdiction over them. Are we clear about all parts of this? I don't want to have to, like, what am I saying? I'm going to have to explain this again. But that's the process. A Nevada district court, regardless if it's federal, does not have jurisdiction over an entity that resides in DC.
Because FINRA has already indicated they're not going to produce them. So if that's the case, then I file a motion to compel in the court that I got.
Would not have power over them. They don't reside in Nevada. End of story.
The subpoena issued in. That's what I would do. Not
Well, that's why you're an idiot blogger and not someone who's a lawyer.
legal advice, obviously.
Oh, not legal advice. Well, then shut up.
The
Like, the lawyers know what they're doing. Like, why are you even talking?
I think you missed what the real aim is here. The arguments about burdensome and oppressive, that's in every discovery dispute ever. So the party that
No, it isn't. But do tell. Like, it wasn't my discovery. Like Pulte's requests weren't burdensome. Like, so that wasn't an argument I couldn't make. Like, and again, even just because it's burdensome doesn't mean it would necessarily be rejected. It would just create a fee shifting situation potentially, depending on how burdensome it is. And they would have to pay that before they would get discovery. So, again, I assume this is Frank Ness. Again, he's like trying to duck and weave and dodge around the substantive FINRA arguments to get to the ones he thinks he can attack. But again, he fails because Frank Ness is a fucking idiot blogger who doesn't know shit about the law.
That could be 2 interrogatories and 3 documents. But
they already told you how many documents it would be. They said at least 23 million. And again, 2004 discovery does not allow you to discover documents, dipshit.
the response, because you have to file a response, the response will always be that it's burdensome and oppressive and all those kind of boilerplate objections. Those aren't the real objections. The real objections are 3 that I saw. 1,
Oh boy, get ready for Frank Ness Explains the Law. I can't wait.
that there's attorney-client privilege information in there. And if there is attorney-client privilege information, that is not required to be produced unless it's been
Yeah, but you still need to make a privilege log for it, and that takes money.
waived before. And that's something that can be agreed upon between the parties. The other thing they referenced
Still requires you to sift through it and create a privilege log. Because you saying that it's privileged material is not the end of the story. You still need to create a privilege log, because then the other party could challenge that. Hey, they say it's privilege. I don't think it's privilege. I want to contest that and pull that out of privilege and put that into discovery. Okay, well then let's do an in-camera review and we'll decide if that's privileged. So, like, again, the fact that this idiot can't even, like, understand basic procedure is going to be fatal, I have a feeling.
was some type of privilege or trade secret. It was kind of elusive. But they claim that the cat and any of those materials are going to be trade secret. So
It's not, no. It's not that it's trade secret. It's the fact that it is by statute a thing that is for regulatory investigative purposes only. So it cannot be discovered as a right of private litigation. Oh my goodness. Oh, I am going to need so much more alcohol if this is how stupid Frank Ness is.
So they're looking at it in two phases, I think. Phase 1 would be if they got the right judge and if they have jurisdiction, then maybe they won't have to produce, and that'd be great.
Do proceed.
But secondarily, and that's the second part of the motion that you haven't referred to, they said in the alternative a protective order. And that's, I think...
Oh, so we're going to skip over all that other substantive arguments and get straight to the protective order part. Oh boy, let's go.
I think ultimately their goal is if in fact they are required to produce any information
They're not, but okay, keep going.
that could be usable by others, that it be subject to a protective order and not disclosed. And that's what I think their intention is, period. So if they're for...
I can see why you're a blogger, dude. You were so lost in the sauce, I can't even.
First to produce the certified audit trail, that it only be used by the parties in the proceeding, not disclosed to the public.
Yeah, that is technically how discovery works. Like, I know you're new to this process, Frank, of using your fucking brain or doing basic fucking research because you're a blogger and not a real journalist. But discovery in a civil litigation is the property of the legal teams involved. Until there is an actual civil case in which it's presented in front of a jury, it is the property of the legal teams involved. And they can choose, unless made, classified or some other thing like that, where it's kept from the public, like, they get to make the decision whether it's made public or not. That is how a civil proceeding works. It's not like some criminal proceeding where all the evidence has to be produced in its public record. It is a private civil litigation. So there is no requirement for it to be publicly produced. That is why I can't go down to the state of Florida and demand the Pulte depositions that happened in the Brandon Jones case. The only reason I got that is because it was produced on the docket by Brandon Jones's lawyers. Because again, This information is the sole propriety of the lawyers involved. It is not public information. Are we clear? Do we understand this process now? Do we get it? Okay. Let's go.
That's their actual intent in all of this. Now, what I would also expect is that
Like intent. There is no intent. That's just how the legal process works. You have no right to any deposition, any evidence, anything produced in any subpoena at all in a private civil litigation. You just don't.
trustees council, after having reviewed the motion and whatever, then to have a further discussion with the counsel for FINRA and agree to limit in part some of the requests. Now, they might limit it like an easy one would be, okay, do not produce any attorney-client privilege documents. That's a pretty easy one, and nobody would really, that would not harm anybody. You might squeeze time frames. You might make some adjustments.
Yeah, that is why this took several months before we got to the motion to quash, because they were having these discussions for the past couple months. Yeah, thanks, Frank Ness. We already knew this because we have operating brains. Thank you.
Adjustments on categories. You would do that for two reasons. One, because, hopefully perhaps it might resolve the dispute about documents. But
Yeah.
two, and probably more importantly, when you file either your motion or your opposition in court, you have shown the court that you went and attempted to resolve it in.
Yeah, that is how the legal process works. Good. I'm glad that he's showing that he has more brain cells than the rest of the people here. But I get the feeling that the point is just to show that he's smarter than he actually is by telling us basic information. But let's go.
Formally, you restricted or somehow limited the ultimate requests, and that will give you favor before the judge. So I would expect.
Well, I mean, meet and confer is not getting favor in front of the judge. You do meet and confer because it's legally required. Like, if there is a dispute, you're supposed to try and resolve it between the parties before you bring it for the judge. It's not just currying favor to the judge. It's legally required under the rules of civil procedure. You have to try and resolve it between the parties before you bring it before the court. Like, every single part of the process, like this is the thing that they miss. Like, every part of this is structured for a reason. Instead of wasting the court's time, maybe you can figure it out between the two of you. And then once you've decided you can't figure it out, then you bring it before the court. Like,
there to be probably some limitation that's placed on the requests, and either there will be an opposition filed. I expect an opposition to the
no shit, Sherlock.
motion to be filed in D.C., and then there'll probably be a reply. And again, I would suggest
Yeah, because that's how the legal process works. You have a movement, they make a motion, then you get a response in opposition, and then you have a reply in further support. And then, if approved by the court, you can have serve replies. That's how the process works. Thank you. Whatever.
not legal advice. I'd file a motion in the
Not legal advice.
bankruptcy court on the flip side, and I would take the position the bankruptcy court has exclusive jurisdiction over this matter and over the subpoena.
Not really, because again, you're going for a non-party that's in another jurisdiction. They do not have exclusive jurisdiction when it comes to subpoenaing non-parties that are outside of its jurisdiction.
Was issued by the bankruptcy court. So that's what I would do.
And that's why you're not a lawyer.
But I don't think it's a big deal. I just think it's business as usual. And until you see the opposition that's filed by the trustees council, you really can't evaluate the motion. You really can't.
I mean, somewhat fair, but like, I mean, I think they're pretty much losing arguments though. Like, the bankruptcy law is 100% clear on how 2004 discovery works. So much so that the court modified them. Like, this has been in the Citadel, like the group filing of Citadel, Anson, and Virtue, and it's also in the FINRA filing. That, like, the court modified it, and then the trustees' lawyers just kind of ignored that, and then expanded the discovery on top of that. Like, are we gonna just, like, totally forget that? Like, if I was the judge, now, probably the reason why I'm not a judge. But if I saw that someone had basically flagrantly ignored my order and then modified it and then expanded it, I'd be like, who the fuck are you? What? Like, I told you what you could do, and then you just decided, oh, that was just a mild suggestion, and we're just going to do whatever we want to? Fuck you, I'm a federal judge.
I told you what I think their aim is, the limitation on disclosure of really the confidential materials. But until you see the response and see how they, the counsel for the trustee, kind of puts everything in perspective, I really don't think you can have a clear idea of the validity of any of their arguments, other than to the extent they made an argument that there's attorney-client privilege information that shouldn't be.
They made more arguments than that, but like, see, this is the part. Is like Frank Ness is really good at making these like somewhat cogent sounding arguments that are actually stupid. Like, okay, yeah, sure, you can't like fully analyze an argument until you hear the other side, but at the same time, like 2004 discovery is pretty clear on what you can and can't do. And if you want this discovery, you could easily get it from the brokers, who you admit are already complying. So like there's so much here that makes no sense, and they're trying to make sense of it, and it is just such a like failed endeavor. Like, it's going to fail 100%.
Disclosed. That one I agree with.
So, Richard, let me ask you. Then, if their ultimate goal is most likely...
Oh, so this was Hoffman, I think? Yeah, it was. That's why this argument made a little bit of sense. Because he's an actual lawyer. But at the same time, like, you're missing basic lawyer arguments. See, this is why I don't like Richard Hoffman, is... Can you message in the YouTube chat to Corax that the guy is talking? Yeah, I just caught on by the time I was at the end of it. Because once they said it was Richard, and I was just like, okay, that's why his arguments make somewhat sense. From a friend, yeah. We both came to the conclusion at the same time. Yeah, he's still missing the point, though. Like, way missing the point. I'll amend it. I'll amend this,
the protective order. Why not file in Nevada, or better yet, considering that
We've already discussed why they didn't file in Nevada. Why do we keep coming back to this? It's so fucking irrelevant. And also basic law. Like, Richard, you're right there. Explain it to them. Like, this is
trustee. Now, granted, we're not privileged to what the behind the doors conversations have been since those subpoenas and orders were.
Then why are you pretending like you know what's been happening? Again, this is the crazy thing with like Junk Savvy and all these people. Is like they try and like if you don't know what the conversations were, stop trying to fill in the blanks with bullshit. Just admit you don't know and move on.
Executed, right? But obviously the trustee has shown themselves amenable to signing stipulated protective orders. They've already done it for 5 entities. So why then do what appears to be a power play and aggressive mood?
Because they're sick of your shit. Like, how many lawsuits have we seen up to this point that have subpoenaed, like FINRA's had to spend money litigating because of you dipshits? Like, I'd tell you to fuck off too. And also, you can get this information from the brokers, so why do you keep bothering me?
Move by filing outside of the jurisdiction.
I'm just done explaining this. I just really am.
If the trustee is amenable to giving you what you think their ultimate goal is, which is the protective order.
That's not what their ultimate goal is. Their ultimate goal is fuck off. Like, if that wasn't clear from, like, the Coruscant case, it should be clear by this point, 12 litigations in. Fuck off. Fuck off with 2 middle fingers.
Because maybe they think they can get a judge to give them to grant their motion to quash, and if that's a better remedy for them.
Yeah, and I guarantee you they'll grant the motion to quash, just like they did in Coruscant. Thank you, Richard.
So what's the risk? There is no risk. There is no risk.
I agree.
If I were their counsel, I would tell them to do the same.
I agree. Again, like, see, like I was saying earlier, like, why not? Like, you're gonna present all your arguments in the best arguments. Like you're gonna present everything. That's the point. It's the point, and Richard gets it.
There's no harm. They don't care about the shareholders. They don't care about, you were talking about the legitimacy of the request. It's irrelevant. They don't care. We're here 2.5 years in. You're talking about good faith and intentions. Irrelevant. This is just a straight legal maneuver.
Thank you!
To limit.
I think I'm giving him a little too
damage.
much credit, but still. I was in the darkness of stupidity, and I just saw a shining light. It may be a train, but I'll take it.
That they suffer as a result of the disclosure of confidential information. It is no more complicated than that. That is it.
Savvy, let's go to, let's let him chime in. I want to give him some time before his heart out. Go ahead, Frank.
Oh, boy. And then we descended back into darkness.
Yeah, what's up, everybody? How's everyone doing?
Doing good. Thank you, sir, for the great article once again.
Yeah, sorry about
Great article. Sure.
the connection issues, guys. So I just want to start out by saying, for those who don't know me, my name is Frank Nez. I'm the founder
I wish I didn't know you.
of Frank Nez Media. Market irregularities and media conflicts essentially.
He's gonna spend the next couple of minutes just masturbating to himself and hope people will go to his blog, right?
Drew me to journalism, and so
Calling what you do journalism is a fucking insult.
I've been writing about transparency and irregularities in the market, and
On your blog.
and stories like MMTLP for quite some time now. But so the thing is, if they manage to successfully quash subpoenas in the metal material case, it gets you thinking about what other companies they can do this to, right?
Well, most serious companies aren't, making frivolous lawsuits about how, the naked shorts are out to get us. Like, you can hear this shit from Apple. No, Apple's too busy making fucking money.
So it's very dangerous. It's very dangerous to see this, and so I think it's important that we do discuss this.
No, I agree. All this is dangerous to idiot cults who have not a fucking clue how the world works.
Being in the media side of this, though, this is why I believe it's very important for investors and the community to raise awareness on these issues as much as possible. This is how we put pressure on our regulators. I mean, just think about the attention that we have received from Congress already, right? So I think it's this effort that will really help the communities propel forward when it comes to dealing with these sort of strange occurrences. They can be a setback, though. I also think it's important to discuss that although this can be a really big setback to the case, especially for MMTLP, there's a chance this won't go through. And I know we can talk about how scary this is, but I just wanted to kind of make that clear as well. I don't really want to discuss how it can just be all gloom and doom, right? But look, guys, regardless of what happens, my message to you is to stay strong and to continue to use your voice, because the truth is we have a lot of power as a collective, and I truly believe in retail investors, and I believe in.
1 second, I got something for this. All right, I'm ready.
This incredible movement. I mean, these incredible people up here speaking today have contributed massively to what's happening and to finding solutions for everybody. And I've stated this in multiple space calls before. All of you guys, every single one of you guys listening, you are part of this movement. And without you, none of the accomplishments that the retail investor community has had would have happened. So I just want to give you guys kudos to that. But I just wanted to pop in here and just say, keep up the good work, everyone.
Thank you, Frank, for the continuous.
Oh, that timed up too perfectly. Oh, I didn't even try. Oh my goodness. Oh my goodness. That worked out too beautifully. Oh my goodness.
Support you've shown from the very beginning, not only to us but overall the retail community, retail investment community, sir.
Real
Let's
quick,
go to Dennis.
Frank, while you're here, how many articles does this make that you've written regarding the MMTLP meta?
Like, who cares? It's like just a dead space.
Fiasco. Do you know?
Hey, Junk. Honestly, I mean, I thought you probably would have a better tally.
I think we're about 20. I seriously think we're about 20. And so you were there, almost right out of the chute. So again, just a lot of heartfelt gratitude to you. And every time we have buzzed you, you've come calling. So just appreciate you and your willingness to cover this. So thank you.
Yeah, no, I appreciate you. I'm pretty sure it's a lot more now. It's a huge library now mixed between MMTLP and FINRA and just regulatory news that I kind of bring in MMTLP as a instance within an excerpt just to kind of plug MMTLP. So there's a lot more, but I appreciate you.
Thanks, Frank. Stick around, Frank. Let's go to Dennis. Dennis Neal, nice to see you.
Oh boy.
What's bugging you today, sir? You have to unmute your mic, sir.
Oh no, is this that guy? Like when they're talking about Dennis, is this the what like? Oh my goodness, is this the Dennis I think? Oh boy. I've never actually listened to this guy's podcast, so let's go.
Dennis? All right, so while we wait for Dennis, let's go with
Technical
Michael.
difficulties.
Does
No
anybody else have
Dennis.
any questions for Frank or Richard Hoffman?
Please,
unmute
no.
and fire away.
I mean, I'll go.
Actually, please, yes. Questions for all of them. Anything to not have to listen to Michael or Bam actually speak.
I think one of the obstacles that's probably there is if you think about like the process of how the blue sheets are pulled, the people that would they have to be.
Is this who I think it is?
Brokers, market makers, clearinghouses, and so even though it says that some blue sheets were pulled, it's probably from the people.
Oh,
that
is
are
this
most
Michael?
compliant with the government? So I don't know if the government's going to want to, punish.
Yeah, it is
more
Michael.
the people who were doing it first, and so especially since most of the most egregious crimes I think are actually out of the country, right? And so that's where there might be some obstacles, is if they have to jump all these different hurdles in other countries where there's other whole legal systems that have to be navigated. They'd have to hire people that know those legal systems, and there's all these roundabout they can send them on legally to keep delaying this in all these foreign countries. I know, for instance, Bed Bath & Beyond, which I know more than MMTLP.
Shit. I'll let this fucking idiot in the door.
It was IPO'd right before bankruptcy in Austria, right? And so that was where a lot of crime was. But even before that, when Ryan Cohen sold in the run-up in August 2022, he sold a huge position. It literally blew up a mid-cap American ETF in London, right? So it's like there's no reason like that ETF would have just blown up. But I think it's because the real trade secrets that they're protecting is how they're using these foreign ETFs and mutual funds to provide infinite locates. And so there's both the firms here that don't want to reveal the secrets, but also the obstacles of just actually pinning down people in other countries.
It just keeps going like the Energizer
right?
Bunny.
So I think that might be one of the obstacles that we have to over. Maybe we can help identify the crime and narrow down what the process would be in these countries. Like for me, it's like, okay, well, I've outlined, hey, the president of Austria literally is also the CEO of their clearinghouse, and he manages the retirement funds for the entire country. And so it's like, to handle the problem.
Yay! So we get another one of fucking.
It's easier to go from there when you identify the
Michael's little
way to go about it, because
finding
it's so different
Pepe Silva.
Hey, Richard, are you trying to say goodbye?
No, I was trying to respond to
Okay,
that.
great.
Yeah. So they, again, I think it was a brief review, but they argued on two bases. So one was that it was privilege and trade secret, whatever. But the other one was it was burdensome. I think that's what you were referring to. So the argument is they made that it would be more burdensome from them, even though they could send out an email to 106 brokers in the United States
Or you could just subpoena the brokers again.
tomorrow and say, send it to us, and that's it. So that's the burden.
No, that's not the burden, Richard. You're a fucking lawyer. You should know all about sorting information into buckets of stuff that can be discovered, stuff that's classified, and stuff that's privileged, and creating a privilege log and having to go through all that information and then having to present it.
Like, stop being a disingenuous hack.
I don't think that's a great burden, but that's the burden.
You don't think it's a great burden because you're part of the cult and you're ignoring stuff that you would normally know as a lawyer because it'd be inconvenient for you to have to explain.
As opposed to, so they say that's a greater burden than the trustee sending out 106 subpoenas and enforcing them. That's their argument.
Yeah. Because if the trustee wants to conduct an investigation for potential litigation, the more direct way to get that discovery is to simply subpoena the brokers. You're a lawyer. How do you not understand this shit?
I don't really think that's a particularly compelling argument.
Yeah.
Because admitting it was a compelling argument would mean getting the ire of the cult. So you're of course not gonna, mention any of that.
I was actually just looking up the system. It is pretty much automated at this point, and
Citation needed.
so they use the actual EBS request system, and it's kind of like a bat signal that goes out to everyone, and then they send their electronic information back, and then FINRA.
How much you want to bet she just did this quickly on ChatGPT, and ChatGPT said, "Sure, I believe your conspiracy theory. Here's the stuff you wanted."
Has a system that aggregates it, so it is by no means burdensome. But Richard, this is the point.
According to you.
That I forgot about earlier. Think about all the hundreds of thousands, if not millions of dollars that FINRA has expended trying to fight transparency.
According to you. And also, again, it would be even more burdensome for them to give the discovery, which is why they always fight it. And also, you're not entitled to it as a private litigant in some cases, like they already said with the cat and with the blue sheet data. And again, you could just get the blue sheet data from the brokers.
Right? But now they're also complaining, Richard, that the financial costs are burdensome. Well, what's the financial cost going to be, 10 times down the road when you have fought us over and over and over again?
Right. Does this bitch actually think she's smart? Because she just really isn't. In the slightest.
When if nothing was wrong, you could have provided this 2 years ago.
Not only that, they're reducing the size of their staff. And this is not like Doge has any control over a private company. This is them electing to do that to either make more money, whatever the reason. It's not going to improve the service they provide to retail shareholders. That's all I know. Curtis, did you want to?
Is there a dead zone here that I'm missing? Oh, actually.
No, I appreciate Richard weighing in and approaching everything from a unique perspective with legal strategy, because you're right, Richard. Take a step back. There's certainly FINRA is not worried about reputational risk at this point. I think that's something that everyone can subscribe to. They've taken more than a few black eyes in relation to their handling of MMTLP.
According to you.
The thing of note is what was assumed before the most recent FOIA releases within the last month is that the SEC likely was aware, but just because of some of the prior FOIAs. But now it is confirmed that the SEC was working in concert.
According to you, and citation needed.
Before the halt, during the halt, and after the halt. And that's extremely important.
Yeah, because they were about to investigate John Berta, which they did, and George Balacaris, which they brought charges against, and that they have already admitted. If you read the motion to quash, they plan to bring a second set of allegations. Everyone knows who the criminals are, and you just don't like that everyone knows that the criminals are the people, the cult leaders that you worship like fucking deities.
Because this is not a decision, and it's not oversight that is limited to just FINRA. It is also right in the SEC's wheelhouse. They were aware, and that's how these are responsive records on the Freedom of Information Act requests that have been granted, is because the SEC is a party on the emails. It's FINRA and the SEC conversing, again, with suspicion of market manipulation, their words, not mine. And they pulled the blue sheets. That's December 5th. During the halt, where they conduct an emergency meeting on December 12th. This is in the midst of the halt. And then after the halt, preparing the first, what was going to become the first public communication that eventually was the FINRA FAQ for MMTLP. And they were both contributors there, although it was only released as a FINRA document. The SEC, and specifically the highest levels of leadership of the Division of Trading and Markets were included. And we can see those emails that they met on it multiple times with recommendations for content.
Yeah, because they were getting ready to charge Berta and George Palikaris. Like, why do you, like, it's been 3 years. Why are you guys still fucking confused about this shit? Other than you want to be confused because it fits your narrative better.
Modification. So anyway, it's a very different narrative than what has been spun for the last 2.5 years. Everyone likely recalls Gary Gensler has infamous testimony in September of 2023. So we're talking 10 months after the U3 halt the next year. And Gary Gensler very quickly separates FINRA's decision as an independent one, not one that was where the SEC was consulted. And he's...
Yeah, because they're allowed to make independent decisions. That's the whole point of being an SRO. And the SEC can choose to regulate it if they want to. Like, what are we even talking about here? I feel like we've lost the plot.
He's speaking as, at the time, the active chairman of the Securities and Exchange Commission. He's separating himself very quickly from FINRA's decision, stating that they have their own rules, of which are approved by the SEC after public comment, but they did not consult the SEC on the U3.
You just admitted that they do public comment and they go through the entire process of that, and then suddenly say that the SEC isn't looped in on this? Like, pick a lane, dipshit. It's one or the other.
Decision. Now, the emails that have been revealed since totally conflict with that narrative. There are numerous narratives that,
according to you,
that show in conflict, including of which SEC email also from Gary Gensler, and even in his response directly back to the open letter signed by 74 bipartisan members of the U.S. House of Representatives, Gary Gensler puts in his very short response that was delivered 6 days after the deadline, but he puts in writing that it is a matter of policy that the SEC does not speak or acknowledge the existence or non-existence of investigations.
Because they're in the process of an investigation, and one of those investigations already has a complaint. We know, based on what FINRA has said and what the SEC has said in the Berta complaint number 1, that there's another litigation coming. Like, are you dense? Did your mom drop you as a child? What's the problem with you, Curtis? Like, everyone else can follow the clues. What, like, you know, do you need a Scooby snack? Like, what's going on here?
And what has been revealed since in FOIAs is that not only do they speak about investigations, about enforcement activities before they actually are
against Berta and Palikaris, yes, and metamaterials, yeah, yep, keep going.
Filed and announced, but they do in their PR, in their press release, where they're announcing the charges against the former CEOs. They also announce an investigation without any charges.
Yeah, because they're already have got a second charge for the whole MMTLP shit. Like guys, you're getting the very thing you want. The criminals are being. It's just not the people that you think are the criminals, so it makes you fucking crazy. Like, there's no fixing stupid. Stupid is forever.
On MMTLP, it flies in the face. This is again February of 2024, and 4 months later, the SEC under Gary Gensler's leadership is again acting in complete conflict with what he's describing, what they do as a matter of policy. So when Richard says what's the loss, right?
According to you,
are FINRA and or the SEC, are they concerned about reputational risk at this point? Obviously not.
And I was
what represent? Like, I don't think FINRA cares about the representational risk to fucking retards.
oh wow, some idiots on the internet think that we're jackasses and aid and abet criminals. 99.9% of the rest of the population doesn't give a shit and actually think we do a good job. I'm not too concerned about the 0.1% that are retarded.
To say, sometimes it's also the cute language that's used, and I don't know if it's true, but, for example, when you use the word consult, right? So, if you want to be cute, so you could take the position, they didn't consult us, they told us, they gave us notice. And, would that technically be correct? Maybe technically correct. Would it be deceptive also? Yeah, it would be deceptive also. So, guys like
What?
Gensler, I think he was a Harvard-trained lawyer. They're very sophisticated in the way they respond generally, and they have somebody who's going to prep them for that kind of thing. So often I think the way they use language is a way they kind of cover for what they really want to disclose. And again, the consultation is kind of like that. The use of terminology can be interpreted all kinds of ways, and you wouldn't be able to get any kind of remedy. It could dispute it. I thought it this way.
Okay, first of all, I hate to bust Mr. Hoffman's bubble, but Gary Gensler went to the University of Pennsylvania. So, yeah. Also, he wasn't a lawyer. He went up through finance and then the Treasury Department and the CFTC and then went to the SEC. So, this is why I can't trust any of them. And this is also why I hate space calls. Because they're filled with rampant misinformation because no one does basic fact-checking or research or anything crazy like that. That would just be, really crazy guys. Ooh, facts, they're scary. But, here's Mr. Hoffman shooting shit out of his ass about how Gary Gensler is a Harvard-trained lawyer. Strike one, he didn't go to school at Harvard. He went to the University of Pennsylvania. Strike two, he wasn't even a fucking lawyer. So,
way somebody else thought it that way. So it was interesting choice of words.
So, guys, what I also think that we're seeing here is we are seeing what is potentially coming down to a showdown between SEC and FINRA.
What? Junk Savvy will just make anything up that she fucking wants to. Oh, well, I wouldn't be able to make fun of someone if they didn't act like an idiot. So, yeah.
So, at what point?
Look, I get made fun of all the time, and you know how many shits I give? Zero.
Are they going to start turning on each other? I think we already saw that in the hearings with Gensler saying, FINRA, they did this on their own, which of course we know that was a lie. But, what is going to happen? It's like you...
Why do people trust Junk Savvy with anything? She is clearly just making up shit on the fly here. Not a fucking clue. Just making up a story as she goes. Just constructing it like a Lego set. How can anyone believe this shit? What?
Said Richard, it's much easier, much more efficient to go to FINRA and get all the trading data from all the brokers than it is to send out 106 subpoenas.
For you. Again, you're the plaintiff. They're a third party. That's the whole point of this. FINRA is a third party. The whole point is that they have no burden. They have nothing about what they're doing. Let's put it this way. FINRA is not a party. They have nothing of this lawsuit has any, there's no way they benefit, nothing. All right, they're an outside party. They're a third party. Like, the fact that they are potentially burdened by this is something that has to be considered. Like, that's the chief thing here. All right? So, like, what'd she even fucking say? Let's back it up a little bit.
It's much easier, much more efficient to go to FINRA and get all the trading data from.
It's more efficient for you, but you are the party to this. The estate is the party to this. They're the one that bears the burden. FINRA is a non-party. It is easier for the party, yes, to go to FINRA, but FINRA is a non-party. They have no horse. They have no horse in this race. They have no dog in this fight. It is not their job to do your work for you, you dumb cunt. If you want to do the work, do it yourself. That is why it's the estate's job to go all the brokers where it is easier to get this discovery. They already have the information. You can subpoena them. FINRA is an SRO. Its information's off limits. You can't sue them. All right? And it's more burdensome for them as a non-party who has no dog in this fight, no horse in this race. Like, that's what this is all about. Oh, I have to do work as the plaintiff to support my claims? I have to support the burden and the cost and expense? Oh, this is such an imposition on me. Get over it. Fucking, you're the one who decided to file this lawsuit. It is not the burden of third parties who have nothing to do with these claims to have to do your work for you. Like, this unending fucking victimhood from meme stock fucking clowns is just impressive in its, like, victimhood. Like, at every turn, they must always be the victim, and it's just sad and pathetic. Do your own fucking discovery.
All the brokers than it is to send out 106 subpoenas. But what happens
Sounds like
when
you
each of these brokers that are already in the process of turning over information?
Well, again, if they're already in the process of turning over information, what are you bitching about? You got the discovery you need. Go away.
Releases data that throws in the face and proves FINRA was deceptive about.
Citation needed. They haven't even gone through the information from the brokers. She's just making this up again. Like, this is all Junk Savvy does. She just makes up shit and lies. And because it fits with the narrative of the cult, they just believe her. She's just a lying cunt. That's all she is.
Their FINRA fact when they said there were 2.65 million. We, of course, have Anson Funds, who is registered. And so they would absolutely have answer to the regulators here in this country. We already have information that demonstrates that they already requested more than what FINRA said was outstanding in terms of shorts. So
citation needed.
Is it just a delay for ultimately something that's going to happen? And how does that even serve FINRA at this point? Because at some point, they're going to be exposed on a massive scale.
According to you.
And then now that we have a new administration at the SEC, you know, Chairman Atkins is in a position where
I love it. I love it so much. Like, this is why we talk about perfect circle theory. Like, the fact that, like, QAnon groups and meme stock are like the Venn diagram between the two is a perfect circle. They're one and the same. Like, this idea that the Trump administration, who hired fucking Paul Atkins to be the SEC chair from back during the, like, 2008 crisis, who the light touch regulators who thought that, you know, the market would just regulate itself. And, like, don't get me wrong, I'm a libertarian. Like, I think that you should have the least amount of regulation that is necessary, but you should still have regulation that's necessary. So you think some light touch, quasi-libertarian Republican is going to advance regulation? Are you fucking kidding me? Like this is what you think is going to happen? That some, like, minimalist small government person is going to pursue claims and expand the regulatory power of the SEC? Are you high? Like, what drugs are you taking? Because I'd like some of that. Like, you must have the good shit.
Going to perpetuate the conspiracy, or am I going to stand up, correct the wrong, and demand the information and from FINRA that proves that FINRA was complicit with the previous administration,
Citation needed.
the SEC, and take the win for the new administration? So I think we could potentially be seeing a battle between these two agencies unfolding here.
But if you're a bad actor like FINRA, and they know the truth, right? They know a lot more than we know, and they know the circumstances. If you're them, again, what's the downside? At some point in time, there'll be a point of reckoning. Perhaps there'll be a point of reckoning. But why?
Oh, you wish there would be. Not likely, though. In fact, I can guarantee it probably won't happen.
I expedite it. What's the benefit if you're FINRA? What's the benefit? And assuming that you engage in misconduct and that the document.
Well, that's a big assumption there, Cotton.
Documents will show that. And you've dicked around, excuse the language, for 2.5 years. You're not a good guy now just because you capitulate. So why wouldn't you, from a practical standpoint?
Easy way to destroy any meme stock DD. Ask for a source when they have the DD targets be right about anything. Yeah, I know, right? Usually get blocked. Exactly.
Why wouldn't you kind of stonewall until the day?
Like, all you have to do to get blocked by a meme stock groupie at this point is just do the Wikipedia thing of the brackets with citation needed. Quickest way to get blocked.
Comes when somebody says you don't have to stonewall. I think that's what I would expect.
At what point? Like, we've already decided that, you look at the Bill of Rights and things like that. Like, there's an inherent right, an inherent protection in our country of right to privacy. Like, it's not criminal to suggest to someone that if you want personal things of mine or my company in discovery, that you need to actually substantiate some claims. You need to actually go the mile to prove that you get discovery from me. Like, this whole nonsense is the kind of shit that I hear from people that are like, well, if you're not guilty, then why should you be afraid of the cops? It's my shit. It's my life. It's my private shit. You don't get to have it. It's wild how these people who talk about people and protecting society, they get all fucking authoritarian the minute they want something they feel personally violated. Everyone's rights are just an object that they can take. It's disgusting.
Expect them to do at all points.
True, but what they didn't expect, Richard, was us and how relentless we are.
Here comes main character syndrome again from Junk Savvy.
And they can stonewall all they want, but it only gets worse for them because of what we continue to reveal. And the list of co-conspirators is getting longer and longer, whereas those members of the organizations may not have been exposed if they had done the right thing in the first place.
Well, how many criminals?
Just the sheer cheek of these people. They think they're so powerful, yet they're so powerless. Like, it reminds me of this quote. I can't remember what it was. It was on my Facebook page. I put it like they talked about like how the 9/11 movement, how they talk about these big conspiracy theories about the Bush administration, and how the whole idea of the conspiracy is how like they're like the objective is to make people feel so powerful within the cult. Like, that's what this whole thing is. It's like it's a coward's fantasy to think that like there's this like shadowy cabal that like it's so fucking idiotic.
Just let's talk about a psychological view of the world. How many?
It's so cowardly, and it distracts people from actual answers and actual things that could do actual good in society, and distracts people with this fucking stupidity.
Criminals turn themselves in or give up, whatever, voluntarily in the world. I mean, the list is very small. And it may not make sense, but that's the practice. Everybody waits until the cops put the cuffs on. So So that could be tomorrow, by the way. It's not saying it can't be tomorrow. I think in part it depends on, and I don't know this part. I don't know Atkins. I don't know ultimately what kind of position he's going to take. I don't know how aggressive they're going to be ultimately.
They're not. Like, there was a reason why Atkins was brought in. Like the dude's compromised. Let's be honest here. If you're looking for actual regulation, if you're looking for the SEC to, like, we already know that for any it's the unitary executive branch. Like, we know from reporting that if the SEC wants to do an investigation, wants to file charges, they have to get permission from Trump and the White House. You think that this is an SEC that's going to, like, expand its litigation powers under a Republican administration? Again, are you high? What drugs are you taking? And if so, I want those drugs. They must be pretty fucking good to hallucinate like this.
I know that they've been involved with a lot of other stuff. They've obviously spent a lot of time on crypto and that kind of stuff. It's taken a lot of their time and energy. But I don't know ultimately if he's an ally or another adversary. I don't know. And he certainly, and the SEC certainly could be our, provide a big assist for us if they become allies. And I don't know where that's going to fall.
Hey guys, I see some hands up, but I want to say goodbye to Frank Nez. I know it's 1 o'clock, Frank. Go ahead, Frank. You have the mic.
Oh yeah, Frank contributed
Yeah, guys,
so much.
just very quickly, I want to remind you guys that, look, at some point they're going to get what they deserve, right? I mean, look, we have already
According to you,
begun to see the industry fingers and throw each other under the bus. So this is just something that is inevitable. And I think the important thing that we can do, which is under our control, is to simply continue discussing, raising awareness, and putting pressure on these regulators, on these bad actors, and keep the movement alive. Keep that momentum up. Because it's that, ultimately, that creates change. So I've been receiving messages and comments asking, well, how do we do something about it? And
I'm going to let this roll because I have a feeling this is going to be a great
the more we talk about it, the more engaged and knowledgeable we are with all this information, the more we can fight back by simply raising awareness. And I've stated this multiple times. Every single one of you guys is doing a great job at giving this the attention that it needs because it is very important. So I just wanted to leave you guys with that. Thank you guys for giving me a space.
Go ahead, Curtis. Thank you, Frank.
Hey, thank you, Frank. And I also have a hard stop here at 4. So I wanted to give special thanks to all the advocates that have showed up. George, Dennis, Frank, Bam, Michael, too many to list. Expertise from Richard Hoffman, always appreciated. You're a rock star. So thank you to everybody. But I don't think we could overstate the importance here. And this is a really good opportunity. I know people get bored with reading legal filings, and there's certainly been a list of them related to these cases. But it is very important to know what FINRA is trying to skirt, which is at the 30,000-foot view, it is their job. They're trying to eliminate being accountable to their job, which is to regulate the markets, to provide data that reveals manipulation when and if it occurs, or if we're wrong, the validation, the data, the underlying data that would prove that there was no manipulation, or that it was solely the allegations that have been made by the SEC. But the data, the truth sets us all free, but not if you're FINRA.
If you're not guilty, why don't you just give everything to the cops? This is such a tiresome fucking argument. I'm so done with it.
That's obvious at this point. I think we all know what the data likely reveals, because the fight to keep it under wraps wouldn't be this great if it didn't reveal something extremely damning on their front. So thank you, everybody. Thanks, Busy. Thanks, Savvy, for coordinating. And I'll be back around if you're still going later. Appreciate it. Thanks, everyone.
Thanks, Curtis. Thank you, Frank. All right, let's go to hands. Richard, how much longer do we have you? For how much longer? Rich.
Till about 1:15.
Okay. All right. Let's go with Liquid 88. John, I did see your hand up, and then Bam or Michael, you could always chime in.
Oh
Go ahead,
shit,
Liquid
we're gonna
88.
get
Hey,
banned
Busy,
at some
thank you
point.
for having such a great space for
Oh,
all of us.
fuck.
Well done. It's great to see all the heavy
Who's
hitters here. You guys,
Wait. Who's this? Like, again, I ripped this so I wouldn't. So I don't actually know who's talking right now. I just have the list of people who are talking. I don't know who this is because I've never heard them.
Mean the world to all of us. I had a question for you, Richard. You know, in light of what's kind of popped up the past week here with the FOIA requests, now that we have factual evidence of a conspiracy with the SEC, do they
Citation needed, and according to you.
assume civil liability to retail shareholders, and are these FOIA requests admissible in court? That's my question.
Every single one of the FOIA requests have pointed in the same direction, that the issuer, Metamaterials, is where the criminals are. But they keep trying to refashion around reality, and it's just not. They can keep trying all they want to. It's not going to work. It's not going to work.
So I can't give you a legal opinion. I would say generally they're immune unless there's an exception. So if it's a civil conspiracy, could I?
I don't always agree with Mr. Hoffman, but man, he just does not go into like super levels of crazy town. Like he can, but like I agree with him more than most of these people. I'll give him that.
Give you an opinion whether that would be an
More
exception.
often?
It's possible. So, and would there be exposure beyond that of a criminal nature if they violated some statute, perhaps? I didn't see the FOIA documents themselves, so I don't know. When people say there's a conspiracy, that's a conclusion, not a fact. And so you could say it appears
Thank
to be,
you! Holy fucking shit! It took us fucking 57, almost 58 minutes for that to come out? Fucking, like, I want to worship the ground that Hoffman walks on. To, like, fucking, like, point out that, hey, guys, maybe you should find facts before you make conclusions? It took us 58 minutes to get to that? Holy fuck!
that's an ultimate conclusion. The problem, with the government entities, unless there's, there's under the Federal Tort Claims Act, there's an exception. So there's potential liability. Could there be a fraud claim or something like that might be fit within the Federal Tort Claims Act and be outside the immunity, perhaps? But there's probably better lawyers that have more experience in D.C. dealing with those entities than I.
And again, like a good lawyer, he doesn't try and talk outside of his bubble.
Okay, thank you guys. Thank you, Richard. Appreciate you.
Thank you.
Oh no, is Richard leaving? Oh no, please don't leave me out here alone, Richard. Defend for myself with these people. No, you have to come back, Richard, please. Don't leave me here alone. Please, Richard, please.
Thank you, Liquid 88. Savvy, did you want to chime in?
Well, just before Richard goes, I want to say to Richard, as I said this morning, absolutely agree with you. This was expected. The only thing that wasn't expected was how long it was going to take to get this.
Why? Like it's a meet and confer. They're going to go back and forth. Like, did you not read the emails from, like, Virtu Citadel and Anson Fund's motion to quash? There was discussions back and forth. There was meetings. There was conference calls. There was emails. Like, what part of this is hard to understand? Like,
But this community is going to do what this community does. And,
yeah, I don't disagree with that. They're going to do very stupid things.
they throw these speed bumps in front of us. We catch some air and we keep on trucking. And I think that there is a genuine opportunity here, as many of us have already discussed, to use this as further indication of obstruction of transparency and obstruction of access to information.
How did Junk Savvy become a thought leader? She's just such an empty bag of air. Like, there is nothing useful that leaves her mouth.
And so we have certainly seen that from our brokers. We have certainly seen that from the SEC. We've seen it from FINRA. We have seen it from the OCC, from the DTC, from the NSCC, from I think I said OTC markets already. We've even seen it at the congressional level as well. But this system that leaves basically retail investors almost no pathway when they have grievances is broken. And as I said before,
According to you,
these regulators are gatekeepers of this information. They have demonstrated their willingness to use it as a weapon,
according to you,
through their enforcement. And there is a new system that needs to be had.
According to you,
Something that holds them accountable, something that offers transparency to investors. And is the new financial system on a blockchain-based system going to be?
Oh, Jesus fucking Christ. Of course we're going back to crypto. Of course. Why wouldn't it be?
The answer to that issue. That really is the question. But like I said, the lack of transparencies allow these regulators to work in the shadows. And when they,
according to you,
rebuff oversight from the only organizations that hold them accountable, i.e. the House and the Senate,
they didn't. Like eventually when it came around, like even the people in the House and the Senate both came back to you and said, yeah, from what we got, it looks surely like, the people that were the criminals were the people in charge, the insiders. Like it's like facts bounce off these people like they're made of rubber. Like they just can't handle it when verifiable information goes against them. But like that's the standard philosophy of a cult. Like one of the things that I had to understand, and I still don't understand it, but like I had to like comprehend it when I read the book Combating Cult Mind Control, and like the philosophy in it I'm really bad at, because you're supposed to like try and that's another topic for another day, but like the deprogramming process that they talk about is you need to find someone who's like close to the person and help them understand that they're in a cult, and it's really hard to do online. And also I'm not the person for doing it, because I'm gonna admit it, I'm kind of an asshole. But like the first thing I had to understand, like I think it was in the first couple chapters of the book, was like when you try and present a person who's in a cult with information that contravenes their ideas, factual information that disproves that what they believe is dumb, it only makes them dig in harder. Like this is one of the big faults of humanity. Like when presented with information that goes against your understanding of how you think the world operates, you just dig in your heels. Nah, you just don't get it. You're lying. You're part of them. How could that be true? You must be lying. And that's exactly what Junk Savvy plays into. Like as one of these little cult leaders who benefits from lying to people. Like she plays into the most base, low, disgusting levels of humanity that they just can't, like, we just can't deal with being wrong. And that's what she plays into. That's so despicable, so low, so vile. Like that's what she does.
Then they are literally just out there on their own without any accountability. And we cannot continue a finance system that is based on that level of lack of transparency. So, but yes, Richard, it was expected,
go ahead. It's time.
and I think that we're going to leverage it to our benefit. And I know that we're in the process of doing
According to you.
that already.
Yeah, one thing suggestion, if in fact whenever you find out who the trustees can, and I don't want I'm not suggesting 500 people do it. It should be like maybe a representative doing it. But whenever the trustees council is selected, whoever's going to oppose whatever the opposition is to FINRA, you might inquire and say that, if you need clarity, we can provide background and assist you. And it might be, speed up the process. If it's new counsel, might provide them information that really would be helpful. If they don't want it, then that's fine. I think you should respect that. But it might be, especially if it's new counsel, it might be really helpful for some representatives to have some communication with them.
I mean, that's probably what we're gonna do anyway. But thank you, Mr. Hoffman. Appreciate it. Can you just stay a little bit longer, please?
Thanks, Rich. Thanks, Abby. Go ahead. It's time.
I just had a little different perspective maybe on the situation of
Oh boy.
FINRA's thoughts here. It'd be like an officer going in a court of law and saying that he didn't feel his body cam footage should be admissible because it shows private techniques.
No. It's not. No. I love examples that have like no basis or context with what's going on here. It's not like the body cam footage. Techniques of how police work. No. It'd be like investigative techniques as to how they process and deal with things. So like, fuck. It's a great example of this. This is not great when I'm like 3 rocks glasses into whiskey. What's a good example of this? Like say like the FBI is planning to put someone as a plant inside the mob. Like the testimony is something that would be admissible. But like how they got the person into the mob, how they got this plant in there, how they, operated within the mob to get the information they got, that would be inadmissible in discovery. Like, do you see how what he's trying to say and what I'm saying is 2 completely different things, and how he's trying to construe it as something different because he doesn't understand the argument he's making? That's the problem I have with this shit. This problem with these people. Like, I am on my 3rd rocks glass of whiskey and can give a more coherent example than some idiot on a space call who is completely sober in this cult. Like, do you understand the problem here? Like, I'm intoxicated, I'm drunk, and I can still come up with a more coherent explanation of how the law being cited works than these idiots. It's kind of bad, right? It's really bad.
Now, if the officer had a concern everyone shouldn't see it, there's already procedures in the court. If the judge
This is like a false equivalency from hell.
believes that, he can keep that within that court.
No.
But why, when we go to the next level that we have, which is the judicial system, they are not allowed to see this stuff?
I mean, if you want to appeal it, you go right ahead. But like, your argument is like riddled with logical fallacies. But like, do continue.
Well, they are, but they just limit they limit the disclosure. The judge will still see it. The parties will still see it. Everybody involved will still see it. Just won't go beyond that.
Yeah, because again, his analogy was talking about a criminal case, which is all public record. We're talking about a civil case, where if it never makes it to trial, it's not a matter of, like, the discovery is not a matter of public record. Like, again, this is just like total ignorance of the legal system and an unwillingness to understand how the legal system works. Like,
But by the way, I should be clear. There's all kinds of different protective orders. That's just kind of a generic term. It really depends on what the language is.
Oh, hey, I hear Mr. Hoffman again, coming in with some help. Please, do explain.
Of the protective order and how broad or narrow the scope is. And, part of that, part of what will happen, again, after the motion is filed, there will be, I guarantee you, there will be discussions, and that will be one of the issues that is discussed between counsel. But to answer your question, what happens is, a lot of times, is people will make an initial declaration that something's confidential or proprietary, whatever, and the courts are very reluctant not to consider something preliminarily that way. But when time comes for a trial or something like that, you can reevaluate those issues. And something that somebody claims was either confidential.
Like, I get he's giving them kind of a false hope here, but, like, it's not wrong. Like, I'm probably going to disagree with Mr. Hoffman on what stuff might be allowed in court, but, like, that's just an honest disagreement. Like, at least, like, of the people on the stage, at least he's making honest arguments. He's not being facetious. He's not being intentionally manipulative. He's just giving honest answers that a lawyer would give. Like, given there's some points that I would disagree on, or I think that he's kind of, like, not giving the full context, but, like, I don't disagree with what he's saying. It's not entirely wrong. And, like, that's better than most of the people that have been speaking to this point. Like, I'll give him that. He's at least he's attempting to be honest, which is better than not being honest at all. Hi, how you doing, Junk Savvy?
Still proprietary. Well, can be reevaluated, and it can be deemed it's, you know, public or not confidential, and can be disclosed. So it can change. It just depends how long the litigation goes on, and if in fact it ever goes to a trial.
And we have 4 more minutes.
That's the key
Richard
point.
Hoffman. Jim, do you have anything for Richard?
That's like the key point. Like, if it ever goes to trial. But again, this isn't a trial. This is just discovery at this point. And even that, it's kind of preemptive discovery. Again, this is 2004 discovery. This is supposed to be stuff where you're asking people that are parties, like you're asking the estate for information as a creditor. This is stuff that you're asking the estate as a party. And it's like, it's not supposed to be documents. It's supposed to be testimony. Like, is the biggest problem with this. If you want to file a litigation against someone, go ahead and do it. And then you get the regular discovery. This is just Wes Christian trying to be a dipshit. Trying to play this, like, fucking end-around game. And it's so disgusting. It's just... Oh, wait. He just said Jim. Are we about to get scam investor talking? I don't know if I can handle this.
I don't.
Okay, Michael. Anybody else with their hand?
Good. No scam investor. Good. You stay quiet, dipshit.
What's up? Any questions for Richard before he drops down?
Yeah, Richard. What about the act that keeps the court cases and everything in your own district? You know, how are they
Oh boy.
able to do that?
Yeah, that was.
Yeah, because like that's the point. The act that keeps things in your own district. Yeah, that's the point. FINRA has its headquarters in D.C., District of Columbia, and it's incorporated in Delaware. So there was 2 choices: Delaware Court, District of Columbia. District of Columbia is where they decided to oppose the subpoena. So there's nothing in violation here.
My point. That was one of the first points I raised. I don't know if there's jurisdiction in D.C. for this.
There is jurisdiction in D.C. because their headquarters is there. Like, remember, it's the nerve test. It's where your company is incorporated or where the nerve center is, where the corporate entity does all of its things, where the headquarters is. So yeah, D.C. is a valid district
for the motion, and that's why I suggested I would first. That's a question, and I looked on when I was before I got on. I took like a 2-second look.
2-second look. Like, that's not a great look, but it's probably more of a look than any of these clowns took.
See if somehow the D.C. Circuit had exclusive jurisdiction over FINRA, and it doesn't. So
it did. I'll agree with them. It doesn't. Like, they could have chosen D.C. or Delaware. It's one of those 2. They chose D.C. But yeah, it could have been either of those 2. Either of those 2 would have been valid, but Nevada is not. That's why they chose what they did.
So I would think that the bankruptcy court, you know, just off the top of my head, I would think the bankruptcy court has primary jurisdiction.
Whoo! And my faith was zapped immediately. No. Again. This is a non-party. They are not a party to the bankruptcy. That's why this is happening in DC. They are not a party to the bankruptcy. They have no interest in this case. They're not the debtor. They're not a creditor. They're not a shareholder. So there would be no way that, and they don't hold any assets on behalf of the debtor or the debtor's estate. There's no reason that the Nevada court, the Nevada District Court, would have any sort of jurisdiction over FINRA.
So that's what I did. And the second part I suggested, again, not legal advice, but if I were the trustees council, I'd file a motion to compel in the bankruptcy court.
You were doing so great. You were doing so good. Why have you forsaken me, Richard? Why?
Do you think there's any legal hurdles as far as things that are outside of the United States that have to do with the stock, like whether that's where the shares were borrowed from or whatever?
Yeah, I'm sure that's a complicating factor. But it's complicating also because we have no idea the number, right? Because I guess FINRA, basically took the position they don't know and they don't really care once it leaves the borders.
Because it might not look like a crime, like if you go to a broker and
Oh my God, is this Michael? This is Michael again. I just can't. I don't want to deal with Michael. I really don't.
Oh, well, we have 100 million shares, but we have them or whatever. We borrowed them from this London or whatever, and then they go to another broker and we have the shares. We bought them legally.
This is Michael. All right, let's speed this up. I don't really have time for Michael. 1.7 sounds good.
London. And it's for example, in GameStop, XRT right now, which is what they use to short GameStop, has 1,300% short interest, right? And it's on Reg Show. And I looked to see who the biggest holder was.
I'm timing you, Michael. Wrap up this shitty argument.
And so it's if they really investigated it, I'm sure that they've lent those shares out from that pension fund a gajillion times, just like Archegos. And so that's the problem is because they know they're not going to sell because they have a bunch of shares, but they really don't have them. And so it's you wouldn't really expose the fraud with the crime being a crime until you saw, everyone's actually borrowing the same shares and they're outside the country and they're not even real shares to begin with.
Yeah, I was going to say you ultimately probably need a forensic accounting, and have a go at it. The other thing is I know, and I think this is a solution too, I don't think they would be really quick at trying to impose this because of the ramifications. But I know that, some of you follow Palantir. So the software that the SEC used for insider trading, detecting insider trading, is Palantir software. Do I believe that they could have somebody create a software program to fully track where everything goes? I believe 100% they could do that.
I need a citation for that. What? Palantir is used to track insider trading? Someone verify that for me, because I think that's kind of bullshit. I think this is the first time that I'm looking at one of Mr. Hoffman's things and just going can I get a citation needed on that? Cause I don't know about that. I really don't. Yeah.
But I don't think they have any particular interest in doing that because of the ramifications it might cause to them.
Thank you, Richard. Thank you, Michael. Savvy, any parting words for Mr. Hoffman?
No, we always appreciate you, Richard. I get up and pretend to know what I'm talking about with the law.
Say the quiet part out loud, are we, Junk Savvy? If only you just kind of, didn't pretend. If only you just, shut the fuck up. It'd save us all a lot of time and trouble.
It's so nice to have somebody who comes in and gives an experienced perspective. But I agree with you 100%. Jurisdiction is going to be one of the biggest arguments that's going to be housed here. And so I suspect what we're going to see is
jurisdiction is not going to be a big issue because it's fine where it is.
Potentially some sort of sort of mechanism, a motion of some sort to claim jurisdiction for.
Nope. And if it is, it'd be a giant waste of time and judicial resources because it's fine where it is.
About it, and we'll see how the Washington, D.C. judge responds.
And Washington, D.C. judge would tell whoever person was opposing the subpoena and saying it should go to Nevada to go fuck themselves.
Yeah, and I think you do a fantastic job, by the way, everybody, in terms of dissecting this stuff, because it's really complex and novel. And, you guys didn't.
Is it though? Is it though? Is it really though? Because I don't think it is. No, it's not that novel, and it's not that complex. You only make it complex because you're trying to work yourself into fucking pretzels and doing fucking Twister over the corner, trying to square your stupid conspiracy theories with reality, and it's just not working for you.
Spend an extra 3 years in law school, so you all do a great job, and it's I know you all try your best, so it's fun for me to hear. It's interesting, and I learn stuff just because you got a different take than I would. I'm pretty sometimes more of a narrow focus, so it's all.
I mean, like, the reason you have a narrow focus is the only reason that this has not gotten like stupid crazy there, Mr. Hoffman. I would not discredit yourself for having a narrow focus. It keeps you relatively sorry, having to switch headsets. Relatively within the realms of reality. Alright. Sorry, my wireless earbuds are about to go die in a ditch. So we're gonna switch to, I'm pretty sure it's this one.
It's interesting.
Yeah.
And everybody just keep up the effort. Just keep it up. It's not going anywhere. It's still here.
And neither. They try really hard, Richard, but
I know.
Greg McCabe's not going anywhere.
What the heck happened here?
We're not going anywhere. You're not going anywhere. And so
What? What the heck?
and neither.
Okay, that's working fine. So you guys are hearing it. Why am I not hearing it? I'm so annoyed.
They try.
Okay, let's go to the other ones. See if that works.
Try really hard, Richard, but
Okay.
I know.
Okay, that works. So, what's the malfunction here?
McCabe's not going anywhere. We're not going anywhere.
Really annoyed. Really super annoyed. Okay, what if I disconnect those? And I go back over here. And I use, there we go. That was the problem. Okay, problem fixed.
They try really hard, Richard, but
I know.
Greg McCabe's not going anywhere. We're not going anywhere. You're not going anywhere.
Greg McCabe's
Greg
McCabe's not going anywhere, according to your unverified text messages. Yeah. Switch to these headphones because they're less intrusive than the others. Yeah, according to your unverified text messages, Greg McCabe's not going anywhere. Do tell us more, though.
Sooner or later. Everybody be well and take care and have a great day, guys.
Thanks, Richard. Appreciate you. Hey, Bam. Welcome.
And the light was crushed by the darkness as Hoffman goes away and leaves us with the idiot squad. How much longer we got? We got like less than 30 minutes. Jesus.
least I got this on like 1.25 speed. Maybe we can get through this idiocy quick enough.
Into our space, is there anything in particular that's tossing about in your mind about FINRA's motion to quash their subpoena in the metamaterials bankruptcy proceeding? Specifically
No,
citing
I just wanted
the
to.
CAT data.
Yeah, nothing specific to that.
Oh my goodness. It's scam investor. Oh shit.
I just wanted to thank you guys again, and then give everyone an update on what I'm working on with.
What a fucking dickhead. I actually have nothing about what this conversation is about, but let me talk about myself. I'm doing all these important things aside from you guys, and you should totally pay attention to them because I'm such a self-important person. Like, in any other group, that like Scam Investor would get kicked to the fucking curb. Like, nothing like hijacking a conversation that has nothing fucking to do with you and then suddenly making it about yourself. What a fucking dickhead.
Another person in conjunction with multiple CEOs, and I'm about to be introduced to some people at the DOJ.
Citation needed, and according to you.
And talk to them. So I just want to give a little more encouragement from another angle. You guys have time for me to review it real quickly?
I love how this fucking shithead comes in and completely hijacks the conversation and makes it about him. That is such a Scam Investor move. What a fucking dickhead.
Fire away, sir.
Okay, cool. Thanks again, Busy and Junk. First off, these guys, most of them call me Bam. My name is Jim Savoldi. I'm fully doxxed. You can look me up on LinkedIn or any of my other social media accounts. I worked at a multi-billion-dollar hedge fund in San Francisco prior to starting my own company. First off, I think one of the most important things we can do as a community is to refer to what this is, this abusive short selling, as financial market terrorism. I found that
Oh my goodness. I forgot this guy also thinks that the people who did 9/11 also are attacking our financial markets. What a fucking fuck me. I hope this guy's not on for very long because he's such a fucking dipshit.
Tends to have people pick up the telephone or want to talk to me, as opposed to talking about retail losing, retail investors losing. Boo-hoo. They don't care. They do care about financial market terrorism. That's exactly what this is. Because right, and the predatory short selling, which led to your whole problem with MMTLP, right? If there wouldn't have been the predatory short selling and counterfeit/synthetic shares in existence, none of what you guys are dealing with would have happened. Okay, the problem with this predatory short selling is that the U.S. small cap stocks are the stocks that are supposed to turn into our huge winners of tomorrow.
Statistically, what is it like? I gotta look this up before I talk out my ass. Approximately 20% of small businesses will fail within the first year. 70 and within the second year, approximately 50%. Within 5 years, 50% of them will fail. Within 10 years, 65%. So, just as a reminder to like Bam's narrative that he's trying to craft here, these small cap businesses are the ones that are supposed to turn into big businesses that like just take over the world. Like within 5 years, most small businesses fail. Within 10 years, definitely most small businesses fail. Like 65% of them fail. There's like a quarter of them that make it to be the Walmarts of the world. Like if that, like even that's probably like a smaller amount. Like 25% of them succeed, and even a small fraction of that turn into like the big cap companies that we know about today. Like this is such a reductive argument, like reductium ad absurdum. Like it's just and this is what BAM does all the time. Like, this guy is yet another one of these people that pretends to be intelligent, but is actually fucking retarded.
Provide jobs, fuel our economy, which fuels our competitiveness against people all over the world, which contributes to the war machine, which, if all of a sudden we didn't have the money to spend on that, it would be like a bully on steroids beating people up on the beach, and then he comes back, 20 years later, he's off steroids, and they're going to kick the shit out of him. So, it's important for a lot of reasons. I like to frame it as financial market terrorism. That's not hyperbole. It's exactly what it is. Other thing I want to mention real quick is because there's controlled opposition all over the place, at the regulatory level, at the government level, maybe even some people on the space right now, none of them that are visible, but who knows, lurking down in the weeds. My approach all along has been just to apply maximum pressure and try to force someone to throw someone else under the bus out of self-preservation. They're not going to do it because they want to. They're not even going to do it because they want to make headlines. They prove that by not following through on what they promised you guys. So anyway, again, hat tip to all of you for pressuring as hard as you are. To circle back and try to wrap this up real quickly. So I reached out and offered my help to any CEO of a small cap company that's experiencing predatory short selling and these guys trying to drive them toward bankruptcy. I had some people take me up on the offer. I'm working with another person. He sort of does his specialty, I do mine. I do in-depth recording of time and sales all day long of multiple tickers. I have terabytes of data over the past 2 years. I've fed that to CEO level people, to lawyers of companies, and it's made progress with some of them. With others, it's sort of a dead end. So I've decided I'm not going to leave this in the hands of the regulators or the government, and that's why I accepted the offer from a CEO to put me in touch with the DOJ. I'm going to show them the recordings I have, and then maybe more importantly, because I'm convinced now from multiple conversations with people, as far as we go, that they understand the problem in detail, and the challenges that they're afraid to pull a lever or even slightly twist a knob because they're afraid they're going to implode the entire U.S. financial market and global financial markets. That's a fact based on the conversation I've had. So this conversation with the DOJ, me along with this other person, we want to offer them a couple possible suggestions, take it or leave it, of how they could, slightly twist the knob, maybe from 10 to 9, and see what happens. I personally would want to start with foreign bad actors, these offshore accounts, and people who are doing predatory counterfeit making, short selling. That's truly financial market terrorism from abroad, and then they can go and start turning knobs a little more, even pulling levers on selectively on people within the United States that are doing this. They're going to run into some big problems, I think, eventually, but we can at least start to see some action. The other thing I want to mention, and I'll wrap it up real quick, is the other thing I'm going to do, so that in case the DOJ doesn't even do anything after I hand them everything I have, which is undisputable evidence in real time of the predatory ladder attacks, and I've called them out hours, days, weeks ahead of time, because I can tell when the algorithm's first set up, and I can tell the target hours and days that it's going to run, and ladder attack the stock down. I know exactly the sequence of different, the algorithmic dance of what they do to accomplish the goal. And if I can do that ahead of time, and I can call it out, with audio over the video in real time, and tell them, a week ahead of time when it's going to hit down to a 2-hour window, and then it happens, that's statistically impossible unless I'm tracking the predatory algorithms. So I'm going to hand that off, but just in case they also ignore what I've given them, I'm going to pretty soon here do simultaneous live stream on X, on my YouTube channel, and on Rumble, and I'm going to show everybody in real time before the ladder attacks hit, them setting up and hitting in real time on multiple small caps. And then, that's pretty much at that point all I can do, and I'll step away. But thanks for letting me catch you guys up on that. Thanks, Abby.
Jesus Christ, finally. Got like 2.5 minutes into this 10-minute spiel of all the collective thinking music from Jeopardy. I was afraid he was gonna go on for fucking eternity like he normally does. BAM Investor is like the soggy oatmeal of financial market grifters. Nothing about him is interesting, and he's the most boring person that could probably be foisted upon you. This whole this right here, this is what it's like to have to listen to fucking Scam Investor, Clockwork Orange, just stop, make it stop,
Thanks, Pam. I actually just want to address one of the questions down in the chat, if you don't mind. Zaniotis is asking, Junk Savvy, is there any way they can change the numbers from the truth? Busy, your thoughts as well. Thank you. So, Zaniotis, yes. And we have evidence
No, you don't.
to prove that. And what evidence is that? We've had enforcement actions where brokerages have falsified blue sheet data.
Citation needed.
And so, yes, it is possible, but that is why I personally believe, my own opinion, that
I'm glad you classify it as your own opinion, because it sure ain't fucking reality.
the trustee subpoenaed in the initial 9 a cross-section of all of the market participants. You've got Anson Funds, a hedge fund. You've got 2 market makers, Citadel and Virtue. You've got 3 regulators that are all going to have similar but yet slightly different data. You've got FINRA, the DTCC, and you've got the NASDAQ. Then you've got 3 different brokers, small, non-existent anymore, mergered. I don't know what the strategy behind those broker selections was, but by doing that cross-section and looking for correlation between the data, it will be revealed very quickly, in my opinion, that somebody was fudging the numbers. So that is why I personally believe that they are doing it that way. And by looking to FINRA for their trading data that's aggregated for from those brokers, that is also a mechanism for looking for correlation and similitude in the data. But do I think they can manipulate it? Yes, I do. They have, and they've been prosecuted for it.
I'll keep it short. I'll respond.
Citation
6 words.
needed.
Full forensic audit, foreign and domestic. Go ahead, Pam.
And they need to audit PwC, right? I mean, I think that's like.
Oh, here comes fucking Michael again. They need to audit PwC.
An angle that we haven't really approached, but like literally, if you look at all the criminals involved, almost every single one of them has the exact same auditing firm. And in fact, we just found out recently that the old SWIFT payment system, the Vatican Bank actually had.
There is not enough alcohol in the world to deal with Michael and his abject fucking stupidity. So we're gonna set this to fucking 2.0 and hope we get through them.
Change payment receiver and sender information even after transactions were sent, and so they're actually consulted. The Vatican is by PricewaterhouseCoopers, right? So one of the biggest things I think is, as far as like getting answers, would be pinning them down. But also one of the people that they audit is Virtue Financial, right? And so one thing that Bill Pulte was pushing for is, he says Virtue Financial needs to be sold, and I think that's because he knows it needs to be audited. And so far it hasn't been sold, but we did get Doug Seaver to step down, so that's a huge win. And also, by the way, it's interesting because one thing that Doug Seaver said to me in one of his comments was, he's like, why don't you just stick on the whole alternative shares thing? He's like, why do you have to bring up Epstein? Like, you can send me a cease and desist. And so that is something that apparently they're scared of, is exposing their guys to actual crime. And after I read on the post today, this one actually started to the CEO of Roundup, and so I have some Epstein connections that I'm going to details, and I'm really excited about it. So it all applies together. This really is financial terrorism, and I think that one of the things is that this is how Epstein was making his money, because he was a tax consultant, right? He was helping rich people avoid taxes, and one of the people was, so most of his money came from the contract from all and so they would pay companies too short, because that meant that they didn't have to pay taxes on that money until they closed their short position and got bankrupt. They never had to pay taxes, right? So you have this like infinite money laundering scheme, and they take all these trust funds, Harvard, your pension fund, and they use those as
Christ, Michael's still going.
Short companies that never have to pay taxes on that money, and so that's why everyone really is Epstein. And the more we expose that, really push those benefits along.
Hey, Michael, we don't want Virtue to be acquired. That's the oldest trick in the book. These guys disappear skeletons, purpose.
Holy shit. Michael just is like the king of just talking on about fucking nothing. Fuck me.
By being acquired by another company. And
oh shit, now it's fucking BAM. Holy fuck, is this like the holy trinity of fucking retards? Ugh.
Matter of fact, if you really look with a critical eye at FTX and the wind down, why did they hold Ledger X, the actual plumbing and the guts of that trading platform?
Apollo Global Management used to.
Recently, I was discussing, if you guys don't know, they
done with
have
them.
kind of finalized the Evergrande collapse. It's been delisted. It's PricewaterhouseCoopers is being investigated and potentially charged by the Chinese government.
What?
For their participation in the shorting and destruction of Evergrande. So, yeah.
No. Also, citation needed, and yeah, according to you. What?
they definitely have a connection, not just to Virtue, who has a connection to them. And
Don't worry, if the bankruptcy court says, show us the information, they got to show it.
Big if true. Again, the bankruptcy court said that the only discovery could be testimony, and they went ahead and did shit the court said they couldn't do anyway. So
pretty much that's how it works.
Thank you, Susie. Go ahead, it's time.
Great for thank
Just
for
a
your
Bam's
insight.
point, when intellectual property, private property, and U.S. investment dollars are laundered overseas, that is financial terrorism.
We're almost to the end of this shit, and I fuck.
You know what to do, homeboy. Busy, Junk, everybody, thank you again. Michael, nice to see you. We're not gonna stop. We're literally not gonna stop. And yeah, so
we know, unfortunately.
Whatever. I mean, do what you need to do, but we'll see you tomorrow and the day after and the day after if we need to. So that's it.
So Mark, in regards of Dennis Neal, he did apologize. He was having connectivity issues, but today was his recording day, so he couldn't stick around. So he apologized.
Yeah, your space was kind of glitchy today. I wonder why.
They are out to get your space calls.
That's okay, but again, in the nest, far left, it's a 7-second clip of Robert W. Cook.
All right, that's enough of this shit. Anyway, to wrap it up, first of all, Genius Group, can you do well, it's not even Genius Group. Genius Group filed their filings correctly through Mark Bazile. X Market News, if you're going to make a filing, can you please read the header on the filing you're making? You said it was a motion to dismiss. It is not a motion to dismiss. The fucking heading, the header of the document tells you what it is. It's a certificate of service. They already got default judgment. Like, can you read? Is reading above a kindergartner level challenging for you? It's literally right here in the header. And it's also right here. Just so you're wondering. Man, I didn't even get to half the shit I wanted to because I still got, what? Oh, yeah, this one will definitely make the baggies angry. Well, we already know that there is a motion to stay because there's a pending settlement in SEC versus Virtu. I'm sure that'll make the baggies happy. I've got fun stuff that I was going to get to. I had fucking Haktua Girls stuff that I was going to get to, but it is currently 12:30 where I am. And having said through that stupidity, my brain needs to heal. So that'll be all for tonight. Hopefully I'll get to it Saturday, or maybe we'll do another live stream. I don't know, but fuck. If I have to deal with another space call that's that freaking dumb, I'll just go back to freaking dealing with Soika live streams or whatever, because like he creates brain trauma, but at least it's nowhere near having 5 idiots circle jerking each other. Anyway, have a great rest of the evening. We're one step closer to the weekend, and that's where we have freedom from our corporate overlords.